Andre Moore hyphen Mitchell present.
Judge Stady has sent Judge Carpenter's docket. It's for a Deshaun DeAndre Moore Mitchell case number.
There's a large notes here.
Are we all right to just pick a date from the calendar? It doesn't need to be on the hearings. Okay.
David Fletcher, do you have Sean Mitchell there?
Oh, they're good. Thank you. Judge Carpenter's JA is out on lunch at 2:00. They don't want us to pick a date from the calendar either.
We do. I can set one up in here, but like I said, if y'all want it to be in front of Carpenini, because there's an information file, then.
Because I don't care. I just want to hear it.
Yeah. So, I mean, I can either leave it up to you guys to schedule it. And we
If
can.
the state's in agreement, we can set it here.
I'm not in a position to make an agreement one way or the other or object.
Okay, well then I guess we can come back at 2:00 and we can call Carpenini's JA and find out what time Carpenini's JA wants to have the hearing next week.
Okay, I will be in courtroom 7B.
I'll be here for a couple of hours, I'm sure. So, for scheduling purposes, is Ms. Smith able to fill in for you when we get done if you're not here?
Sure, she can, if it is able to be set without me being here, my schedule, I'll make accommodations for whenever it's set. And again, I don't care whether it's heard here or whether it's heard in front of Judge Carpenini.
Sure.
We just want to get it set.
Information has been filed. I think it naturally at that point would go in front of Judge Carpenini, but we'll can't give you a hearing right now because there's no one to give me a hearing. So we'll try to do it before we leave today. How about that?
Thank you, Your Honor. I'll return unless I get an email from Ms. Smith.
Got it. Good to see you, Mr. Slaughter.
Thank you. Good seeing you, Judge.
So like, hold on one second. I want to get back into my routine and I'll call you once I do the speech and get Mr. Hernandez to do the speech.
Yes,
If you don't mind.
no, I don't mind.
I'm a creature of habit. All right, Deputy Letchworth, you got the microphones.
Yeah, I know.
All right, good afternoon, everybody. Judge Stamy here in Polk County for first appearance hearings. I can see everybody at South County and Central. You don't have to stand up, but could you please raise your right hand? And Ms. Hernandez, you don't have to repeat this. I'll do it one by one when the Spanish comes up. All right,
Yes,
everybody, raised. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? If you agree, say I do.
Okay.
Great. Everybody that said I do, put your hand down and we can make sure everybody's hand is down. It sure looks like everybody's is, and so everybody's sworn in. All right, Mr. Hernandez, I'm going to read the advisory. And when I'm done, could you please read it in Spanish?
Yes, Your Honor.
Good afternoon, everyone. This is Judge Stamy here at the Polk County Courthouse. This is your first appearance hearing. A first appearance hearing has 4 purposes and 4 purposes only. First, I will advise you of the charge or charges that have been filed against you. Second, I will ask if you have an attorney representing you. If you have hired counsel and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward today with your hearing or postponing it until tomorrow. If you postpone the hearing until tomorrow, it is your responsibility to contact your attorney to let them know you will have court tomorrow. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, I will ask if you can afford one. If you can't afford one, we'll make a note of that. We'll proceed forward. If you cannot afford one, and if you qualify, I can provisionally appoint the Office of the Public Defender to represent you pending your formal filling out of an application. You have a right to have your attorney present before and during any questioning. Third, if there are any challenges to probable cause, I will address those challenges. And finally, I will review your bonds and/or other release conditions with you to determine if any changes are needed. Please be aware if this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go into effect immediately, meaning even while you remain in custody. For example, if you are told to have no contact with a certain person, let's just say the alleged victim, and you call that person from the jail before you are released, you are in violation of your pretrial conditions. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located as here at the courthouse, as well as where you are located at the jail, is being recorded. There is an assistant state attorney present listening to everything that is being said, so do not say anything about the crime itself. Please keep these rights in mind as we go through the process, and please step forward when your name is called.
Buenas tardes, esta es su audiencia de primera comparecencia. La audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, les informaré acerca del cargo o los cargos que se han presentado en su contra. En segundo lugar, les preguntaré si ya les está representando un abogado. Si ya ustedes han contratado un abogado y éste se encuentra presente, entonces será el abogado quien hable en representación suya. Si su abogado no se encuentra presente, usted tendrá la opción de proceder con su audiencia de hoy o posponerla hasta mañana. Si usted decide posponerla, será su responsabilidad el contactar a su abogado para hacerle saber que tendrá una audiencia mañana. Nadie más hará esto por usted. Si usted desea proceder sin que su abogado esté presente, puede hacerlo. Si usted no tiene abogado, le preguntaré si puede pagar uno. Si usted sí puede, tomaremos nota de eso y procederemos. Si no puede y califica, el juez asignaría provisionalmente a la oficina de abogados de oficio para que le representen en espera de que usted llene una solicitud para estos servicios. Usted tiene derecho a que un abogado esté presente antes y durante cualquier interrogatorio. Tercero, si hay alguna objeción en cuanto a motivo fundado, esta se abordará inmediatamente. Finalmente, voy a estar revisando sus fianzas y otras condiciones de liberación con usted para determinar si es necesaria cualquier modificación. Debe saber que si el juez lo pone hoy bajo libertad condicional, independientemente de si es directamente o como condición de su fianza, las condiciones que se anuncien el día de hoy en esta audiencia entrarán en efecto inmediatamente, aunque usted se encuentre aún encarcelado. Por ejemplo, si se le ordena no tener contacto o comunicación con alguna persona determinada y usted llama a esta persona desde la cárcel antes de salir en libertad, ya estaría violando su libertad condicional. Durante todo este proceso, usted tiene derecho a permanecer callado. Si decide no permanecer callado, todo lo que diga podrá ser usado en su contra. Todo lo que diga donde yo me encuentro, así como también donde usted se encuentra, está siendo grabado. Hay un abogado de la Fiscalía presente escuchando todo lo que aquí se dice, así que por favor no diga nada en relación al delito mismo. Por favor tenga presentes estos derechos durante el transcurso de este proceso. Favor de pasar al frente cuando se llame su nombre. Gracias. Thank you, Your Honor.
Thank you. Give me
You're
one
welcome.
second. I had something that's come in on the duty judge phone while we're sitting here.
Absolutely, Your Honor.
Who are you here on?
Mr. Blanks.
Mr. Blanks, okay, why don't we go ahead and do that one now then?
Thank you, Your Honor.
No problem. And Mr. Blank had a note here telling me which one you're here on.
Last name is Bush,
Bush. Okay.
Skyler.
All right, let's call up Skylar Bush.
And Judge, all blank on behalf of Mr. Bush, at the moment, limited notice of appearance until further discussions with family. If I may, we needed to confirm, there was no warrant on this. This was a PCRS.
Yeah, there's no warrant that I've seen. It's, looks to be an arrest report from the sheriff.
And Your Honor, based on the reading of the report and the manner in which it was written, arguably you can find probable cause on counts 1 and 2 without reading the tampering.
Let me just ask you, do you want me to read these? I normally.
No, I was going to take, you can waive reading.
That's what I'm saying. When you.
That's why I said 1 and 2, and the tampering, although I do have a challenge argument to that. And if I may, especially if you go to the PC affidavit on the very last paragraph, if I may approach, I got mine underlined.
I've got mine right here.
Okay,
Just show me where you want me.
down there, the underline at the bottom, that whole area.
Last
Yeah, oh, you got it underlined.
Well, I read these, Mr. Blank. I read.
I didn't say you didn't. But the argument here is the destruction of any emails or text messages. The reporting deputy or detective is raising it to the level of constituting to destruction of potential evidence. Well, under the statute, that's not the standard for, it's not probable cause. Under statute, that they're alleging he violated is 918.13. I may approach, I can hand you that statute, unless you have it.
I have the statute.
Oh, no, this is a lot easier.
I have the statute books here if I need to.
And the underlying portions are what's pertinent from my argument. That the individual has to know that the case is pending or is about to proceed. And even based on how the deputy or detective wrote, it does not indicate there was any knowledge of any pending investigation or case. So with regards to that, that is my challenge to the probable cause for that count.
Let me do this. All right. Mr. Bush, you're here for 3 things. 3 charges have been filed against you. We have one that's a 2nd-degree felony, punishable up to 15 years in prison. And then we have 2 separate 3rd-degree felonies, each punishable up to 5 years in prison. Mr. Blank has told me that he's here today on your behalf, but as of right now, he hasn't agreed to do it he's not fully been retained. So just so you know, and anybody sitting behind you, if anyone says to me today, Judge, I have a private attorney or I'm going to try to hire one, like in this case, just because you pass on the public defender today doesn't mean you can't ask for it tomorrow or the next day or the next time you're in court. Just because you're trying to hire an attorney, something might go south and that doesn't happen. So if you say you want to hire an attorney today, you can always ask for the public defender later if you change your mind. I've looked over the affidavit and I've heard Mr. Blank's argument. So kind of put this into context. Devin, what you have on your paperwork is number 1 is the one that we have yet to talk about or continue to discuss. Mr. Blank has conceded there's probable cause for 2 and 3 as it appears on your paperwork. And before I get into the bonds, let's address the state's response to the probable cause for the remaining 3rd-degree felony tampering. Ms. Perry, go right ahead.
Your Honor, I would argue that based on the fact that he said that he was destroying the evidence, could not be used against him if discovered, indicated that he had knowledge that someone would attempt to discover it. Also, based on the nature of his occupation and the fact that he was working within that occupation when engaging in the behavior. I'm trying to not give away what the other count is, but while engaging the behavior, I would argue that based on his knowledge, training, experience, the capacity in which he was working in, and the direct quote from the defendant, that we can tell that he knew one would be instituted.
And then I would argue the statute controls, not what he knew or would know, but you'd have to know that there was a pending case. Based on the writing of it, there was no pending. There was no knowledge.
And again, I've read this entire thing back in my office, but you've pointed to a certain area. I don't recall there being any independent investigation that talks about deleting text messages. Only it's contained within that one area of the conversation or the interrogation, if you will. Would you agree? I mean, go back to the whole thing again. Fair to say that any mention of tampering comes from a conversation with him.
From whatever their conversation, whatever's in that paragraph is contained in that, but still the letter of the law.
Yeah, no, I was just asking. I mean, again.
And I honestly, I'm not the author of that, so I don't know, because as you know, law enforcement rights reports, that's not written how people talk. That's how the author of a police report writes. So I would have to argue it is, except, and since we're going is in the facts that the statute controls tampering, even tampering, you have to know there is a pending investigation or case, and there's nothing in there to indicate that he had any knowledge of a pending case.
Or anything else?
No, Your Honor, I would just argue because we're going off what's articulated in the affidavit, that they've articulated the capacity in which he was working, his position and training, and the direct quote by him, as well as the fact that if you look at paragraph 3, he's also made communications in relation to our count 1 that would indicate he had knowledge, he had communicated regarding that potential charge to a third party, which would lead someone to have knowledge there could potentially be an investigation.
Still doesn't fit. You have to have knowledge of a pending case.
And I think knowledge can be shown circumstantially, Your Honor.
Knowledge is what's between the old ears, only one person really knows what's in there unless they admit to knowing what's in there. And so, yeah, knowledge is like a theft from Walmart, just because you push an item falls through your basket down to the bottom and you don't see it and you go past all means of checkout, you buy $300 worth of groceries, but you didn't see that the chapstick fell down there. And you get out of your car like, oh my gosh, I didn't pay for the chapstick. Well, you didn't commit a crime because you didn't intend to do it. But certainly if you push the cart out and you start looking around to make sure no one's seeing you walk out the front door, well, those are all circumstantial. But again, it's what's between the ears. That is what the state has to prove. I will tell you, and again, I agree with you, you have to show that he had knowledge that there was a pending investigation, about to be a pending investigation instituted. I see a lot in here. I see a lot of charges where drugs are dropped. And I get a lot of tamperings that don't involve, throwing them down the drain, flushing them down the toilet, just merely dropped. So I always struggle with not that there's an investigation, but what the action was. Here, your argument is that he doesn't know that there's an investigation instituted or might be instituted.
Right, where your example of somebody, a defendant dropping drugs is basically inferring that law enforcement is in sight, and rather than somebody 2 days before drops some weed on the, out of the window, and that's not tampering. So you have to have the knowledge, and so far what's not articulated in that report is knowledge. But that's my argument.
I get it. I guess I was kind of getting off on a tangent that we're here. There's actually allegation is it was destroying or deleting versus just dropping something. So your argument is not that he didn't allegedly delete it. She didn't know that there was an investigation that was instituted or about to happen. Candidly, I hear the arguments a lot from both sides, but the point is there's such a low bar here, and it's probable cause. It's for purposes of first appearance, and I always tell people that look, if I'm going to find no probable cause for count whatever, then and you're going to be staying in jail for a while, I'm doing you no favor because you're not getting any gain time. So that being said, I believe at first appearances, what I've read, is enough for probable cause for that charge. As much as I appreciate your argument, I think, and Ms. Perry's point, what's between someone's ears, what someone believes is, unless you have a mind reader, you look at what they do and how they behave to infer whether or not they have knowledge of something. I believe it's almost like a circular argument that he's destroying it because he's fearful that an investigation is started or is about to be started. So he destroys it. So it's kind of like, that's how I look at it. And I agree. We don't always have to.
That's fine, Judge.
Yeah, no.
I just make the argument. You make the
Yeah,
call.
no, I get it. I just want to say that for first appearances purposes, I believe there's probable cause. So I'm find probable cause on all three charges. That being the case, would you like to be heard as it relates to bonds?
Well, the state and I've already talked partially about that, since he is a resident, lifelong resident of Polk County, he's been in the military and he still resides here in Polk County. And you can see from his address where he resides, his family is here in the courtroom with us. He's not a flight risk. He is, and I would add that the F2 is at the level 5. It's only 28 points when you're looking at a bond and so forth. And based on his lack of history, not of who he was or is or may never be again, it is not pertinent. What is pertinent is, will he appear in court, and to ensure his appearance in court and not to thwart the criminal process and protect the community. I would suggest that as far as the two bonds for the F3s, $1,000 on each of those would be appropriate. I think the standard for other bonds have gone up to 5,000, but and not inappropriate there. As far as the F2, 15,000 would be sufficient. And I know the state has requests for pretrial release conditions and so forth. She didn't agree to what I just said. So.
Ms. Perry, what about you?
Your Honor, the state would ask for an elevated bond based on the nature of the charge, the type of position that this individual was in, and the type of person involved on the other end of the F2 charge. Your Honor, I would argue that an elevated bond would be appropriate. Additionally, Your Honor, I would also ask for specific conditions in addition to elevated bonds. I would ask that the defendant be placed on a GPS monitor so that we can track his whereabouts. I would ask that there be no contact with anyone under the age of 18. And I would ask that he not be permitted to use internet or internet-related services. That way, Your Honor, if communications are made, they will be means which cannot be deleted to prevent destruction of any further evidence.
That would.
I'm sorry, Mr. Running. I'm just having them.
I didn't know if she was
pull up
talking
the
to you as
form.
well.
No, you're good. Go right
I
ahead.
didn't want to. Are you? Okay, I just, as far as the GPS, if you have GPS, which it's not as offensive, but there you have to pay. If you know where he is all the time, why do we need an elevated bond such as whatever that exactly means, elevated? So I would submit that 15,000 is sufficient, especially if you're imposing GPS monitor. As far as no contact, unless he has minor children, he has 2 minor children. I would request that they be excluded from that no contact provision. And if necessary, I can have his spouse advise the court who's in the courtroom, advise the name and ages and so forth of those children just for that purpose. So as far as no internet, it's kind of hard to do these days. If you're on watch TV, it's on the internet. If you're talking about internet devices like computer or cell phone.
Section 25 of the standard pretrial order.
To the state.
This is in possession of any devices capable of access.
Well, your TV is capable of that. So that means somebody can't watch their smart TV. So I would like to, if that is in practice of cell phones or emails or cell phones or computers, but it has to be rational and reasonable where you go. So if the court's willing to allow him to have contact with his 2 children, I would request that he be here from his.
The children's ages?
I would have to ask that.
Yeah, I mean, and I'll see what Ms. Perry's position on that one is as far as carved out exception for his own children.
I would object to contact with any minors, and Your Honor, at this point, we don't know if there's any type of case plan.
There are two males, ages 6 and 3. So I would, but it's not relevant to which.
Just make sure you heard what Ms. Perry said is,
No.
is that, basically she's not, she would object to contact with, at this stage, with any minor. And she's not aware if there's any case plan in place by Department of Children and Families that would kind of.
I would have to argue based on the affidavit that there is nothing to concern, based on their investigation before making an arrest, there is nothing to impose that type of sanction on somebody pre-trial. I would admit that's overburdensome and inappropriate for, especially when they're 6 and 3 males and not in this scenario.
Anything else from either one of you?
Unless I need to push more.
Just have, I want everybody to feel like they have a fair chance to be heard. All right, Mr. Bush, having found probable cause for all 3 charges, just so you and everybody behind you knows, we have standard bonds in this county. There's an administrative order that tells you for a misdemeanor, the bond is this much, for a felony, it's this much, for a higher felony, a serious felony with violence and things, it goes even higher. So my intention is to give you what I consider to be standard bonds. The standard bond for an F2, which is punishable up to 15 years in prison, that bond is a $15,000. So in the F2, that'll be what it is. On the remaining 2 charges, it's $5,000 per count. So you add it up, it's $25,000. I'm going to make those bonds a condition of pretrial release. So if you post those bonds, you have to immediately check in with the Office of Pretrial Services here in Bartow. It's right over here on Highway 17, right by County Probation as you're leaving Bartow going towards Fort Meade. It's on the right side of the road, on the west side of the road. You have to report there. So if you get released after business hours, you got to go the very next business day and sign up with them. If you get released on the Saturday or Sunday, go Monday morning to get signed up. Sign up in person. And while your case is pending in the system, I want you to call 3 times a week, Monday, Wednesday, and Friday, just to check in with them on those 3 days. You have all the conditions that anyone else has while on pretrial release. We call those standard conditions. Plus you have the following special conditions specific to you in the charges. Number 17, you are not allowed to have any intentional contact with any of the listed victims, in this case, the victim. This means directly, indirectly, or through a third party. Stay 500 feet away from her, her home, her vehicles, where she works or where she goes to school. I'm also going to do condition number 22 and 22A, which I won't recite here, but it can be explained to you when you're released from custody, or when you, at the time that you sign up with pretrial release services. I'm not going to do a GPS, and I don't believe, based upon the facts of this case, that the internet prohibition is appropriate. But I am going to do 16, 22, 22A. You have questions about? Yeah. So the defendant and or the list, the witnesses, there's a prohibition on you having contact with the victim and or witnesses that have been identified in the police reports. So in special condition 17, 22, and 22A. Okay. Any questions? And just keep in mind, anything that I'm not going to be your judge, anything that I've done today is always able to be revisited by any judge that's assigned to your case.
I don't do it. Maybe it's
Have a
good.
good day, Mr.
Thanks, sir. Take care.
Am I allowed to see my kids?
Yes, absolutely.
That's the only question we had on it.
You bet. Ms. Jones.
Good afternoon, Judge.
Good afternoon. Who would you like for me to call up?
Jimmy Leaks.
All right, I think I had that pulled.
And the PD stepped up.
She probably stepped out because Ms. Jones is going to represent on this. She saw an opportunity, yep. All right, let's call up Jimmy Leaks.
He's requested.
Mr. Leaks, good afternoon, sir. You're here on 1 count of domestic violence, battery by strangulation. That's the 3rd degree felony. Ms. Jones, you be representing him on this case?
Yes, Judge.
All right, so you told you what you're charged with. That's number 1. Hired, that's number two. The third thing is that I determined probable cause. Any challenge, I do have a warrant.
I don't, Judge, and I was gonna say this is a warrant case anyway.
Yeah, Judge Hill has already reviewed this affidavit and he has made the determination that there is probable cause, so he signed off on a warrant. Now, I have also reviewed the paperwork just to be prepared for the hearing. So that's step three. Step four is bonds. Ms. Jones, would you like to be heard as it relates to bonds?
Yes, Judge, we're requesting a standard $5,000 bond.
Okay. Anything from you, Mr. Matthews?
No, Your Honor, thank you.
Mr. Jones, the standard bond for this third degree felony, you might have just heard what I told the last gentleman, it is $5,000. I'm going to set your bond at $5,000 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services. Sign up in person, calling them on, I think Wednesdays is appropriate. Every Wednesday while the case is pending, you must call into that office. You have all the standard conditions everyone has, plus special conditions 16 and 17, which says you can't have in your possession weapons, firearms, ammunition, or guns. You're not allowed to have any intentional contact with a listed victim. This means directly, indirectly, or through a third party, say 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. Anything else?
I'd just like to put on the record and make sure that Mr. Leaks knows, there was a request from the victim for nonviolent contact. I know that's not available to us today, and that's something we'll handle with the trial judge.
I was just gonna say, the warrant doesn't show any contact from the victim.
I don't think pretrial release has
Okay.
either. I have had contact with the victim, but I know the court can only take that into
Yeah.
consideration.
Yeah, if I had some input from the alleged victim, I certainly could consider that. I just didn't have it. I did see that from the affidavit, it appears as though they resided, the victim and the defendant resided in the same residence. If that's accurate, I'll go ahead and do condition 18 too.
Yes.
Just in case. That means, sir, you get to return to that home. If you bond out one time within 48 hours of getting out of jail, you can return with the police along with you to retrieve your essential items like medicine and clothing. Have a great day, sir. Nice to see you, Ms. Jones.
Thank you.
Hey, Your Honor, can we please take one out of order here at Central? We have one that needs to go back to the infirmary for oxygen tank flow.
Yeah, we can do that, and then we'll get Mr. Caleb. Who would you like to call up?
Easton?
Maybe.
All right, it's Elizabeth Easton. Pull her out.
Okay.
Ms. Easton, you're here on, looks like 4 new charges, and then you also have a second charging document where there's a direct information filed by the state attorney. So a 5th charge. I'll go over those in just a moment, but ma'am, do you want me to appoint the public defender on all 5 of these charges?
Yes, ma'am. Yes, sir.
That's close enough. All right, I'll go ahead and appoint the public defender to represent you on all 5 of the charges. The charge on the direct information is for felony petty theft from Walmart. So I find probable cause for that standalone single charge on the information, and I'll set your bond at $5,000. Now, all the other 4 charges are found in a City of Lakeland Police Department affidavit. I find probable cause for these 4 charges. They are possession of methamphetamine, and I'm going to set your bond on that at $7,500. Possession of cocaine, I find probable cause, and your bond is $7,500. Felony petty theft, this one's from Belk at the lakeshore there in Lakeland, so that's $7,500. And lastly, the possession of drug paraphernalia, $2,500. That looks like if we add those all up, that looks like $30,000. I'm going to make those conditions, those bonds, a condition of pretrial release. So if you're able to at some point post that $30,000 bond, you have to immediately, upon getting out of custody, report to pretrial services, sign up with them and call them on Tuesdays and Thursdays. You have all the standard conditions everybody has on pretrial release, plus the following special conditions. You are not allowed to have any intentional contact with either of the victims. And I'll expand the Walmart. By Walmart, I mean, you can't go to any Walmart, any of them, no Sam's Club, not any of them, and you can't even go to any Murphy gas stations. They're owned by Walmart. In addition to that, you can't go to any belt. So in addition to that, I'll go ahead and for just posterity, put in there that you can't go within 500 feet of the event location. So no contact with either of the victims, and you can't go within 500 feet of the Belk that this occurred at or the Walmart this allegedly occurred at. I think I've covered it all. Mr. Matthews, any other conditions you're asking for?
No, Your Honor, thank you.
You bet. Have a nice day, ma'am.
Thank you.
Yeah. Mr. Kaler, who are you here on?
Good afternoon, Judge. I'm here on behalf of Zuleika Serrano. Last name is Serrano with an S. And I'm here for the limited purpose of first appearance hearing at this point.
All right, let's call up Zuleika Serrano Alago.
You can't hear the interpreter.
And Ms. Hernandez, you're,
Judge, I don't believe she needs the interpreter.
yeah, I didn't have her down as an interpreter case. So ma'am, I apologize. I do have her down as an interpreter case. I misspoke.
Well, then, let's roll
Mr.
with it.
Hernandez, would you be able to ask the young lady, is she requesting your services? And you are muted, or your microphone's not working.
Still not working.
Yeah. We'll wait for you if you want to hang up and come back in.
Judge, I mean, honest, Miss Serrano, do you speak English?
Quito.
Well,
She'll
Judge,
come right back, Mr. Kaler. I don't think it'll take
All
but
right.
a second.
all right.
Yeah. It wouldn't be first appearances without some technical computer, microphone, speaker issue. It's a daily
Well, it
battle.
doesn't get worse than that.
Today's been pretty mild. We just couldn't hear our interpreter. So give us time. We might have some other.
Well, maybe I'll stick around.
Your Honor, can you hear me now?
I can. I thank you, Mr. Hernandez.
You're
So
welcome, Your Honor.
let's call up the case of Zuleika Michelle Serrano Alago.
Llamemos el caso de Zuleika Michelle Serrano Alago.
She's been charged with the crimes of aggravated assault with a deadly weapon and battery.
A ella se le acusa de los delitos de amenazas con agravantes con arma mortífera y de agresión física.
Ms. Serrano, Mr. Kaler's told me that he's here today for the limited purpose of first appearances.
Señorita Serrano, el señor Kaler me ha dicho que él se encuentra aquí el día de hoy para el propósito limitado de su primera comparecencia.
If you end up hiring him, great, that's your decision. But if you end up after today wanting the public defender, just know you have every right to ask at any court date moving forward.
Si al final del día usted decide contratarlo o no, esa es su decisión, pero si después de todo usted decide que quiere un abogado de oficio, usted tiene todo derecho a solicitar un abogado de oficio en cualquier otra cita que tenga ante el juez.
Mr. Kaler, do you have any probable cause challenges to the two charges?
Señor
No, Your
Kaler,
Honor.
¿tiene usted algún reto u objeción en cuanto a estos dos cargos?
No, Your Honor, I just would ask the court to impose the $5,000 bond as to count the aggravated assault account.
No, su señoría, nada más quisiera yo pedir que imponga la fianza de $5,000 en cuanto al cargo de amenazas con agravantes.
Ma'am, I reviewed this affidavit from the sheriff and I find probable cause for the two charges.
Señorita, yo ya revisé el informe del alguacil del condado y encuentro que sí existe causa razonable para estos dos cargos.
Your bond on the aggravated assault will be $5,000.
En cuanto al cargo de acometimiento o amenazas con agravantes, la fianza es de $5,000.
Your bond on the battery is $1,000.
Y en cuanto al cargo de agresión física, la fianza es de $1,000.
These bonds will be conditions of pretrial release.
Estas fianzas serán condición de su libertad condicional.
If you're able to post those bonds, you must immediately sign up with the Office of Pretrial Services.
Si usted puede pagar esas fianzas, usted deberá inmediatamente registrarse con la Oficina de Libertad Condicional.
Call them twice a week on Tuesdays and Thursdays.
Después de eso, llamarles 2 veces a la semana, los martes y los jueves.
Your special conditions are as follows.
Y sus condiciones especiales serán las siguientes.
You cannot use or possess firearms, weapons, or ammunition.
Se le prohíbe usar, poseer o portar armas de fuego, armas blancas o munición.
You cannot have any intentional contact with the listed victim.
Se le prohíbe tener cualquier tipo de contacto o comunicación intencional con la víctima nombrada.
Stay 500 feet away from her as well as her home, vehicles, place of employment.
Tendrá que permanecer alejada de la víctima en todo momento, por lo menos 500 pies de distancia de su persona, su residencia, vehículos, lugar de empleo y escuela si es que va a la escuela.
Have a nice day.
Que tenga buen día.
Thank you, Judge. That's all I have before the court. Have a good day.
You too, Mr. Kaler. Next up, we have Manuel Perez.
El siguiente es Manuel Pérez.
Sir, you're here based upon a violation of probation on 2 charges.
Señor, usted se encuentra aquí debido a un incumplimiento de probatoria en cuanto a 2 cargos.
You want me to appoint the public defender?
¿Quiere usted que yo le nombre al abogado de oficio?
Sí.
Yes,
I'll do that.
eso haré.
There's probable cause based upon Judge Harb's warrant.
Sí existe causa razonable basándome en la orden de arresto firmada por parte del juez Harb.
He wants you held no bond.
Él pidió que no se le otorgara fianza.
Your next court date is May 26.
Y su siguiente cita ante un juez será el 26 de mayo.
Next up is Juan Vargas Gatica.
El siguiente es Juan Vargas Gatica.
Sir, you're here having been charged with operating a motor vehicle without a driver's license.
Señora, usted se le acusa de conducir un vehículo sin una licencia válida de manejo.
Sí, correcto.
Yes, correct.
That charge has been upgraded 1 degree based upon your unlawful entry into the country.
Ese cargo ha sido aumentado, señor, debido a que usted entró ilegalmente en el país.
Do you want me to appoint the public defender to represent you?
¿Quiere usted que le nombre a un abogado de oficio para que lo represente?
Sí, está.
Yes.
I'll appoint that office to do just that.
Voy a nombrar esa oficina para que lo hagan.
Sir, I've looked over the affidavit from the Lakeland Police Department.
Señor, yo ya leí el informe policíaco de la agencia del alguacil del condado, perdón, del departamento de policía de Lakeland.
I find probable cause and your bond is $1,000.
Encuentro que sí existe causa razonable para este cargo y su fianza es de $1,000.
You currently have a hold on you from ICE.
Actualmente usted tiene una orden de detención por parte de inmigración, ICE.
Because of that, I'm going to ask the clerks to prepare a detainer for my signature.
Debido a esto, yo voy a pedir a las escribanas que preparen una orden de retención para que yo la firme.
Have a nice day, sir.
Que tenga buen día, señor.
Ms. Hernandez, would you mind making another announcement?
Of course, Your Honor. Buenas tardes. ¿Hay alguna otra persona que necesite intérprete en español? Por favor, levanten la mano si es así.
2 o'clock, Judge Carpenter.
Just call him and see if he has a time available. We said,
The parties, Mr. Solarsno is asking for a hearing time for an adverse preliminary hearing on the case where information has been filed. All right, Ms. Hernandez, I don't see any takers. Thank you so much.
You're welcome, Your Honor. May have a good day.
You too. Any other privates or any other attorneys waiting to be heard? All right, hearing nothing, we're going to quickly tackle the gentleman there at South County, move on to the ladies at Central. First up, we have Luis Arroyo.
Sandra Smith, Polk Defender's Office. My understanding is alleged victim does want to have contact with him and apparently did not want him to be arrested in this incident. So I would ask for no violent contact.
Mr. Arroyo, you're charged with domestic battery. Do you want the public defender?
Sure.
I'll appoint them. I've looked over the Davenport Police Department affidavit, finding probable cause. I'm setting your bond at $2,500, making it a condition of pretrial release. If you post bond, immediately check in with that office. Sign up in person, call them on Wednesdays. All the standard conditions plus special conditions 16 and 20. 16 says you're not allowed while you're on pretrial services to possess or carry any firearms, weapons, or ammunition. 20 says I am, based upon the victim's wishes, allowing you to have contact with the victim, but this contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner. Have a nice day, sir.
Step to your left, sir.
Next up, we have Deshaun Laquan Brooks. Mr. Brooks, you have warrants from Leon County. Looks like there's a total of 4 of them. I cannot appoint the public defender here. But you can always hire a private lawyer if you want, or wait till you get back to Tallahassee and ask for a public defender. I've looked over the paperwork provided. Looks like the judge up there, I find probable cause, and it looks like the judge up in Leon County has made it known that their wishes for bonds. On your charge of petty theft, the bond up there is $250. On your charge of aggravated battery, there'll be no bond. On your charge of aggravated assault with a deadly weapon, no bond. And on your charge of kidnapping, false imprisonment, there'll be no bond. If there's nothing else holding you in our jail, like local charges, Polk County will call Leon and say, all right, fellas, come get him, he's yours. If for some reason you're still in our jail a week from today, you'll be brought back to talk it over with the judge on May the 6th. Have a great day, sir.
Yes, sir.
Obviously, more persons, though, I can. Again.
No, Mr. Samars, no, we, Scavry, our clerks continue to try. We've had no luck with Judge Carpenter's office. So we'll keep trying.
Thank you, Judge. Fortunately, I have Wi-Fi access, so I'm just doing my stuff here.
No problem. You're more than welcome to hang out. Next up, we have David Diaz. Mr. Diaz, you're charged, it looks like add-on type charges. There's a total of 1, 2, 3, 4, 5, 6, 7, 8 add-on type charges. I suspect you probably already have a public defender on this case number with Matthew.
It's a different case.
So even though they call them add-on and they identify them as counts 31 to 38, it's a dependent separate case, do you believe her?
I believe he has Lee Cohen on the other case. I don't know if he's privately retained or court appointed.
He is a private attorney, Your Honor.
Yeah, Mr. Diaz, are you planning on hiring Mr. Cohen for these charges as well?
Yes, Your Honor.
Okay, you heard me say that if you're unsuccessful or fail in that endeavor, you can always ask for the public defender at any point in the future. Sir, I've looked over the Lakeland Police Department affidavit. Having reviewed it, I find probable cause for these charges. Mr. Matthews wants to be heard as it relates to bonds.
Judge, I just asked the court to especially consider the amounts in question and the allegation of the use of the court system to accomplish that goal when the court is assessing an appropriate bond. Thank you.
You know, does he have a companion case? If so, is he on pretrial release?
He is on previous pretrial.
13, 16, 17.
I would
Now,
not
notice they call in.
I'll have to check on that.
Yeah, just to. So, Mr. Diaz, as they're looking up what days the previous judge has you calling into pretrial, I don't want to duplicate or have you do separate call-in dates and have you do the same as you previously were doing. But while she's looking that up, having found probable cause there's 3 separate counts of grand theft, $100,000 or more, Those charges are first-degree felonies. I'm going to set your bond at $25,000 on each of those 3 counts. Then you have 2 counts of use of an ID of another without consent resulting in $50,000 in loss. That also is a first-degree felony. I'll set your bond at $25,000 per count on those 2. The next charge is scheme to defraud greater than $50,000. With probable cause having been found, it's $25,000 bond. The next charge is tampering with evidence in a felony of the first degree proceeding. Your bond will be set at $25,000. And the last charge is a third degree felony, unauthorized practice of law. I'll set your bond at $5,000. Those bonds will be conditions of pretrial release. If you post those bonds, I'm going to give you the same day to call in that the previous judge did, which is Tuesdays and Thursdays, twice a week. You have all the standard conditions plus the following special conditions, 13, 16, and 17, which is you can't possess or consume alcohol. You can't go to bars, nightclubs, or lounges. No possession of weapons, firearms, or ammunition. No intentional contact with a listed victim. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. Have a nice day, sir.
Thank you.
That brings us to Christopher Hall. Mr. Hall, you're here on a charge of a defendant failing to comply with terms of conditions of pretrial release on an underlying charge of DUI 0.15 or higher. So on this charge, Mr. Devon, does he already have an attorney? Yeah, this is Mr. Christopher James Hall.
Yes.
Already has an attorney. I've told you what the charge is. You have an attorney. I find probable cause because I'm looking at Judge Kaler, Stacey Kaler's bench warrant. So finding probable cause, she wants you held no bond, but she wants you to go see her within 5 days so y'all can discuss it. We'll set you up to see her on May the 1st, which I believe is what, Friday?
Yes.
Well, you'll go see her on Friday. Have a good day, sir.
Is that what, this is arraignment? Is he having-
8/29.
Is he having a hearing at the same, oh, okay.
It just, Devin says it's a 5-day hearing on 8/29, 5/1 and 8/29.
Okay, thank you.
You bet. Hey, Ron Lewis Casey. Ray, hey, Ron Lewis Casey. Sir, you are charged with 2 counts of domestic violence battery, 1 count of domestic violence aggravated battery, and 1 count of domestic violence false imprisonment. Do you want me to appoint the public defender?
Yes.
I'll appoint them. Sir, I've looked over your affidavit. I reviewed it in its entirety back in my office, finding probable cause for these 4 charges. Mr. Matthews, go right ahead.
Judge, with regard to the count domestic violence, aggravated battery with a deadly weapon, aggravated battery is an enumerated dangerous offense. This is a second-degree felony before the court. The state is filing a motion for pretrial detention and providing a hard copy to appointing counsel. May I approach? I'm providing the original to the court. I would very respectfully request the court review that motion for facial sufficiency, and if so found, hold the accused no bond pending a hearing on this motion, which should be set for next Monday. I believe it's the 4th, but next Monday at 1 p.m. on the A2 docket. Thank you.
Anything from the defense, Ms. Smith?
No, Your Honor.
Mr. Casey, I've got in front of me a 2-page document that's been titled "A Motion for Pretrial Detention" pursuant to Rule 3.132 of the Florida Rules of Criminal Procedure and Section 907.0415 C5 of the Florida statutes. I have looked over this document. I do find that it's legally and facially sufficient. I want to give it to the clerk to file in the court file. And because I found it legally and facially sufficient, I'm going to hold you no bond on the 1 charge of aggravated battery. You'll go see the circuit judge on May the 4th at 1 p.m. On the remaining charges, I'm going to set your bond on the false imprisonment at $5,000, having found probable cause. On each of the 2 counts of domestic violence battery, I'm going to set your bond at $5,000. If you are able at some point to bond out, and right now you have no bond on the 1 charge, but if you're able to bond out at some point, these bonds are going to be conditions of pretrial release. If you're able to post those bonds, immediately check in with pretrial services, sign up in person, call them daily. You have all the standard conditions everyone has, plus the following special conditions. Make sure something real quick. Yes, sir. Based upon the size of impairment, I'm going to order that you not possess or consume alcohol. You can't go to bars, nightclubs, or lounges. You'll be subject to a random urinalysis that tests you for alcohol, and that's at your expense. I'm going to tell you that you can't possess or carry any firearms, weapons, or ammunition. You're not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from her home, her vehicles, where she works, or where she goes to school. Because you resided there with her prior to being arrested, you get to go back one time if you're able to get back onto the streets. And you're able to bond out. You go back one time with the police within 48 hours to retrieve your essential items like medicine and clothing. And I'm going to order, based upon the death threats, I'm going to order that when you post bond, if that occurs, that you be held by the jail until such time as you've been equipped with or outfitted with a GPS monitor. I'm not going to put you on house arrest, but I really want to know where you go at all times. Specifically, I want to ensure that you don't go within 500 feet of the victim, her home, her vehicles, where she works, or where she goes to school. The GPS monitor is the best way for me to try to accomplish that. All right, sir, step to your left. Sure.
I didn't understand how much it was.
Next
So
up,
what was in bond?
his bond was 15,000, which is 5,000 per count on the F3s, but he has no bond on the ag battery. Next up, I believe, is Johnny Mackey. Mr. Mackey, you're charged with introduction of contraband into a detention facility. You want the public defender?
Yes, sir.
Appoint them. Looked over the sheriff's paperwork, finding probable cause. Your bond is $5,000. Have a great day.
Yes, sir.
Charles Miller. Mr. Miller, you have an add-on charge. It looks like it's a grand theft. You want me to appoint the public defender?
Yes, sir.
All right, I'll go ahead and appoint that office to represent you. That's what I thought it was an add-on, so let's see. All right, yeah, this is all right, sir. I'm appointing the public defender. I've looked over the city of Lakeland's affidavit. He came through first appearance previously, but this was a March 11th incident, so I'm guessing he went on pretrial or bond after March 11th.
That is correct.
So it's not a Parker situation. All right, sir. Finding probable cause, since you have earlier cases, I guess these earlier cases, are they theft-related cases? Felony petty theft. And that one also pending the burglary? Felony petty theft, burglary with a grand theft. All right, sir. I'm going to set your bond on this charge here at $10,000 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Monday, Wednesday, and Friday. You have all the standard conditions that anyone else has, plus the following special conditions. You're not allowed to have any intentional contact with the victim. Stay 500 feet away from the victim's property. You're not allowed to go to any academy sports, not only the one in Lakeland, but anywhere else. Condition 21 says you have to stay 500 feet away from the event location. Step to your left, sir.
Judge,
Yeah.
I received a response from Judge Carpenini's office. I had to email them. They said that we can set the preliminary for Friday at 9 a.m.
This Friday or next Friday?
This Friday.
That's fine, Judge.
Very well. Thank you, Judge. I thank the courts for their diligence.
And that's, you said one?
It's going to be this Friday, May 1st at 9 a.m.
9 a.m.
Yeah. Carpentini.
Thank you, Judge.
Have a good day. Good to see you, Frank.
Yeah, good to see you.
Pleasure, sir.
Good to see you, sir.
Okay.
Yeah.
Okay, yes, let me pivot back. This is Mr. Miller. So, yeah, Mr. Miller, just to be consistent with the previous judge, which, hang on, go up, which was me. Yeah, I'm gonna do the same thing. Why deviate? 16, 17, 21, those are all things I gave you today, but I'm gonna add the GPS monitor because that's what I did previously. And so instead of Monday, Wednesday, Friday, it'll be daily calling with the GPS monitor. All right. Thank you, sir. All right, next we have David Ritchie.
Yes, Your Honor.
Mr. Ritchie, you're here on 2 local charges, and you also have warrants out of Lake County, 3 of those. Do you want me to appoint the public defender on the local charges?
Yes, sir.
Appoint them. I've looked over the paperwork, both from related to the local charges and from the warrants out of Lake County. I can tell you that I find probable cause for the Lake County warrants. The charges are domestic battery, aggravated battery caused by being a battery on a pregnant woman, and aggravated assault. The judge over there wants you held no bond on each of those 3 charges, so we'll hold you no bond on those. Turning our attention to the local charges, domestic violence, assault, and kidnapping. Does the state want to be heard as it relates to probable cause?
No, Your Honor.
Just on bonds?
Yes, sir.
Yeah, I've reviewed this, Mr. Ritchie, and I find probable cause. I reviewed it back in my office. So with probable cause being in place for the domestic assault and the kidnapping, state wish to be heard?
Yes, Your Honor. With regard to the charge of kidnapping, that is a first-degree felony. It is in the enumerated dangerous offense. State is filing a motion for pretrial detention. I'm providing a hard copy to appointed counsel. May I approach?
Sure.
I respectfully request the court review that motion for facial sufficiency, and if so found, hold the accused no bond pending a hearing on this motion, which should be set for next Monday, May the 4th, at 1 p.m. on the A2 docket. Thank you.
For the kidnapping alone, that charge?
Yes, sir. The domestic simple assault is not a qualifying offense. Aggravated assault would be.
Ms. Smith, anything from you?
No, Your Honor.
All right, Mr. Ritchie, I have this document in front of me. It's 2 pages. It's been titled Motion for Pretrial Detention Pursuant to Florida Rule of Criminal Procedure 3.132 and Florida Statutes 907.0415D. I'm finding it legally and facially sufficient. As a result of that, I'm going to hold you no bond on the kidnapping, and we'll send you to see the felony circuit judge on May the 4th at 1 p.m. On the remaining charge of domestic violence assault, you set your bond at $5,000. I'm going to make the 2 local charges, the bonds, I understand on the one you have no bond, but I'm going to make the 2 potential bonds conditions of pretrial release on these 2 local charges. So if you're able to post the bonds at some point and you're able to make it onto the street, you have to immediately check in with pretrial services, sign up in person, and call them daily. You have all the standard conditions that everyone else has, plus the following special conditions. You are not allowed to be in possession of, nor can you carry firearms, guns, weapons, ammunition, or knives. You can't have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from her, her home, her vehicles, where she works, or where she goes to school. And because of the nature of the allegations, I believe a GPS monitor is appropriate. I've told you can't have any contact with the alleged victim, and I certainly mean it. So I'm going to order that before, if you're able to post bond at some point, you have to be held in the Polk County Jail until such time as you've been outfitted with, equipped with a GPS monitor. I'm not putting you on house arrest, but I want to know where you go at all times. Specifically, want to make sure you don't go within 500 feet of the victim, her home, her vehicle, where she works, or where she goes to school. Step to your left, please. Eves Jerry St. Clair,
No.
you're charged with
Man,
resisting
you said Eves Claire.
violence.
That's not me.
She's combative. This is Sutherland.
All right. Do we have a Eves Jerry St. Clair?
He was combative.
Well, he was combative. I'm sorry. So do we want to bring him back tomorrow, Ms. Smith?
Yes, I would just ask to accept tomorrow.
Well, good news, I'm coming back tomorrow, so another judge doesn't have to read this affidavit again. So we'll bring that gentleman back tomorrow. Now we have John David Sutherland. Mr. Sutherland,
Yes,
you're
sir.
charged with burglary and petty theft. You want me to appoint the public defender?
Yes, sir.
All right. I'll go ahead and appoint that office to represent you.
Yes, sir.
Sir, I have in front of me the Polk County Sheriff's Office affidavit. I find probable cause for the petty theft and the burglary.
Yes, sir.
Looks like you have an open case of a misdemeanor. Can you tell me what that is?
Trespass after warning.
All right, sir. As to the burglary, and I understand it's not of a dwelling, but of a shed, I'm going to set your bond at $7,500. Having found probable cause for the burglary and the petty theft, I'll set your bond on the petty theft at $2,500, making those bonds conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services. Sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions, plus special conditions 17 and 21. You're not allowed to have any contact with the victims. Stay 500 feet away from them, as well as their homes, their vehicles, where they work or where they go to school. And of course, you need to stay 500 feet away from that shed, which is the
Yes, sir.
event location. Now, because I found probable cause for these charges, and because you're out on bond on a trespass charge, I'm going to go ahead and revoke your bond on that case, holding you no bond pursuant to the authority of Parker versus State on 26 MM 3301. I will appoint the public defender if you don't already have them representing you. Have a
Yes,
nice
sir.
day.
Yes, sir.
All right, Deputy, I think that's everyone there.
Yes, sir. Thank you.
Moving on to the ladies. We have Jashayla Blackman. Ms. Blackman's charged with domestic violence, false imprisonment, and giving false information to a police officer. Ma'am, do you want me to appoint the public defender?
Yes.
I'll do just that. I've looked over your sheriff's office affidavit. I find probable cause for the two charges. Going to set your bond on the false imprisonment at $5,000. Your bond on the knowingly giving false information to a Leo related to an alleged crime, I'll set that at $1,000, making these two bonds conditions of pretrial release. If you're able to post those bonds, immediately check in with pretrial services. Sign up in person, calling them on Wednesdays, all the standard conditions, plus special conditions 16, 17, which says you can't have weapons or firearms in your possession, and you can't have any intentional contact with the listed victim. Stay 500 feet away from him, as well as his home, vehicle, and place of employment. Have a nice day. Next up, we have Crystal Carr. Carr looks like she's a bringback. Ms. Carr, you're here on two warrantless VOPs. The docket says Alachua, but the affidavit said Pinellas. So, Ms. Smith, have you and Mr. Matthews had a chance to look up the DOC website to make sure?
The DOC website shows Alachua County.
Yeah, that's what the jail has, Alachua. I just zeroed in.
I'm on supervision in Pinellas.
Yeah, she's Clearwater is supervising her, but she's on probation. But the incident did occur in Alachua.
So it's an Alachua County crime.
Yes.
She's being supervised in Pinellas.
Yes.
She got herself arrested in Polk.
Yes.
All right. Clear as day. All right, ma'am. So that certainly explains it, because I was curious, because the jail had you down as Alachua, but the policeman indicated it was Pinellas. Well, it makes sense that you're supervised there. So ma'am, you're here for the two VOPs. I cannot appoint a public defender in Polk County for an Alachua County crime. You can hire a private lawyer if you wish, or wait till you get back to Gainesville to ask for the public defender there. I've found probable cause based upon the paperwork that I've reviewed. The judge up in Gainesville wants you held no bond. Actually, not the judge up there. I'm choosing to hold you no bond based upon the nature of the VOP. So we'll hold you no bond. If there's nothing else holding you in Polk County, we'll notify Alachua that they can come get you. If for some reason they haven't come to get you by this time next week, on May the 6th. We'll bring you back to talk it over with the judge. Have a nice day, ma'am. Lori Den is charged with a new charge of resisting without violence, and she has an older charge of failing to appear for an arraignment on a charge of violation of a noise ordinance. Ma'am, do you want me to appoint the public defender for these two charges? Actually, it would be public defender on the public defender on the resisting, I should say. So I'll appoint the public defender for them. I find probable cause for that charge. I find probable cause for both charges. I am going to release you on your own recognizance on the failure to appear for arraignment on the noise ordinance. It looks like that was, yeah, that's here in Bartow. So it's not, I was thinking it was a Lakeland case. It's not. Judge Williamson did it. With the M7 division, it looks like. So I'll release you on your own recognizance on that one. Can we give her a court date? So it looks like for both of these, she'll be going to see Judge Gibson on May the 15th.
I believe so, yes.
Yeah. So on the resisting, ma'am, I'm going to set your bond at $1,000. So probable cause for both. 1,000 on the resisting. You'll be released on your recognizance on the noise ordinance. You're hearing it straight from me, okay? You're supposed to be in court here in Bartow, May 15th at 8:30. So make sure you're there, or the next KPS won't be an ROR, it'll be for higher bond. Have a great day.
Judge, are you appointing a court-appointed attorney to the other one?
I'm not, I mean, it's arraignment, it's a noise, she can certainly take it up with Judge Gibson then, since she's being released. Certainly, she can hire an attorney if she wishes. All right, looks like we're up to Jasmine Gianni. Ms. Gianni, you're charged with domestic violence battery. Are you planning on hiring a lawyer, or do you want the public defender?
Public defender.
I'll go ahead and appoint that office to represent you. Ma'am, I've looked over the affidavit that's been provided by our local sheriff. I find probable cause for this charge. You don't have any ties to Polk County. That's certainly something I should factor in. Just so you know, bond is not meant to punish you. Bond's meant you're innocent until someone proves you guilty. Bond's meant to make sure you come back to court when you're supposed to. The fact that you live in a state far, far away and have no ties to Polk County factors into what I want to do. You say she does have some prior history too. Disorderly conduct. All right, ma'am, what I'm going to do is I'm going to set your bond at $2,500, having found probable cause. I'm going to make that bond, if you're able to post it, a condition of pretrial release. So you must, if you get out of jail, you must immediately check in with the Office of Pretrial Services, sign up in person, calling them on Wednesdays. I'm going to delete special condition number 10. I understand you don't live in Florida, and I assume you want to go back home. Well, the bond is what's meant to keep you coming back. So I'll delete condition 10, which otherwise would have said you can't leave the state of Florida without getting the court's permission. Because you clearly live out of state, I'm gonna let you return home, but you got to come to court when you're supposed to. You have all the standard conditions plus special conditions 16, 17, and 18, which says you're not allowed to use, possess, or carry any firearms, weapons, or ammunition. You're not allowed to have any intentional contact with a listed victim. This means directly, indirectly, or through a third party. I see that you and he live in the same home back in your home state. So you're going to have to, if he's still there, you're going to have to find somewhere else to go. You're not allowed to live in the same home that he's living in. But because you resided there with him prior to being arrested, I will let you go back with the local police up there one time within 48 hours to retrieve your essential items such as medicine and clothing. And then you need to find somewhere else to move. Have a great day, ma'am.
Thank you.
Next up is Cheryl Johnson. Ms. Johnson is charged with failing to appear for pretrial conference on a charge of criminal mischief. You already have regional counsel. I find probable cause. Judge Kaler, set your bond at $250. Have a nice day, ma'am. Next one is Kayla Kraus. Ms. Kraus, you're charged with resisting an officer without violence. You want me to appoint the public defender to represent you?
Yeah.
All right, I'll appoint that office to represent you. I've looked over the sheriff's affidavit, finding probable cause. I'm going to set your bond. I believe that enhanced bonds are appropriate based upon the allegations in the record. I'm going to set your bond at $2,000 cash or surety. Have a great day. Next up is Tammy Myers. Ms. Myers, you're charged with a violation of probation. What put you on probation was petty theft. You want the public defender?
Yes, sir.
I'll appoint the public defender. I have Judge Harb's warrant in my hands, so I find probable cause after reviewing it. He wants you held no bond. We'll hold you no bond and we'll send you to see him on May the 26th. Have a
Okay,
great
thank
day.
you so much.
You bet. Takiria Mary Lavina Odom is charged with trespass on property. Is she not available?
She refused.
She refused. You want to bring, she's currently at a no bond. You want to bring her back tomorrow and see if I'm here again tomorrow.
One moment, yes, I'll just reset tomorrow.
All right. I'll go ahead and, bring her back tomorrow. Like I said, I've already reviewed it, so that's good. Another judge says I have to. That brings us to Heather Osborne. Ms. Osborne, you're charged with, the way it's been identified, it's a felony petty theft. Says you have a petty theft with 2 priors. Do you want me to appoint the public defender?
Yes.
I'll appoint that office to represent you. Ms. Smith and Mr. Matthews, I've read it pretty quick, I'll acknowledge, but I only see, I believe the officer might be under the mistaken belief that 1 prior is all that's needed, much like a battery, because the only one he lists is criminal history check completed. It shows she had a prior felony petty theft conviction out of Polk County for April 18, 2025. Therefore, the suspect is being charged with felony petty theft. Unlike a battery, it takes.
Yes, I suspect if it was a felony petty theft in the past, that there are other petty thefts prior to that, but I do not see them named in the affidavit.
Yeah, you might be absolutely right. They saw a felony petty theft, and oh, she's got a prior. But yeah, a battery only takes 1 prior. DUI, it takes at least 2. Other charges like petty theft, it takes 2 priors because it goes from M2 to M1 to F3. All right, so ma'am, I'm not going to find probable cause for the F3, the felony of the 3rd degree, because there's no allegation that there's 2 priors. I will find probable cause for the M1 petty theft, which is based upon a petty theft with 1 prior. I do believe, based upon your extensive criminal history, that enhanced bonds are appropriate. So I'm going to set your bond at $2,500 and make it a condition of pretrial release. If you post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Wednesdays. All the standard conditions plus special conditions 17 and 21. You can't have any contact with the event location or the victim, which in this case, of course, is Dollar General. You have to stay 500 feet away from any Dollar General. You can't go there while your case is pending. Have a great day, ma'am.
Thank you.
That Jaleesa Sellers.
Yes, Your Honor.
Ms. Sellers, you're charged with battery on a police officer. It also looks like, I see this as a bring back, but the affidavit I have for Ms. Sellers, I see that, Mr. Devon, you only have 1 count battery on a Leo.
That's because they missed one, at the last court date. She wasn't booked in on it yet.
Is that, see, that explains it to me, because her affidavit shows the battery to resisting. So is this a situation where she wasn't booked in on one of the 2?
Correct. We've already been appointed in her case when she came to first appearances on April 26th. She wasn't booked in on the 2nd battery, so obviously bond couldn't be set on it at the last hearing. So I just asked for a bond to be set on that as well. Judge Ojeda had first appearances with her on April 26th.
So it took them 3 days to get her, but even though she was arrested on one, it took 3 days to get her arrested on this, or booked in on the second.
Apparently.
I'm delighted because candidly, when it says bring back and that kind of thing, normally you would think to be bring back tomorrow. I'm thinking, I don't remember this. I hope I'm not,
It was
my memory's not fading on me because I didn't remember reading this yesterday. So I'm glad you said it wasn't yesterday when I was here. All right. So only thing, ma'am, the only thing you're here for with that explanation is, of course, the battery on a law enforcement officer that it looks like you were slow in being booked in on. You already have a public defender appointed on the entire case, and it covers not just the one the other day, but this one as well. So you have an attorney. I reviewed the paperwork, I find probable cause, setting your bond at $5,000. Did Judge Ojeda put her on pretrial release?
No,
It doesn't seem so.
Okay, yeah, so he didn't put you on pretrial release. I won't either. Have a nice day, ma'am. The next one we have is Nancy Sharpless. Ma'am, you're charged with driving under the influence. Do you-
Your Honor, she's medically unable to show up for first appearance today.
Medically unable.
Lisa Kimura, Your Honor.
All right. Medically unable. So we'll bring her back tomorrow. And again, I'm glad it's me tomorrow, so nobody else has to be inefficient. Read that again. Natalie Nicole Valentine.
Take your object, please.
Ma'am, you're charged with possession of cocaine and possession of drug paraphernalia. Do you want the public defender?
Oh, yes.
All right, I'll appoint them to represent you. I've looked over this affidavit from the Lake Wells Police Department, finding probable cause, setting your bond at $5,000 on the cocaine, $1,000 on the paraphernalia. Step to your left. Aubriana Williams. Miss Williams, you're charged with domestic violence battery. They allege there's a prior conviction. Let me take a look at that. Yeah. Third up from the bottom indicates you do have a prior conviction for simple battery. All right. So ma'am, do you want me to appoint the public defender to represent you?
Yes.
I'll appoint him. Looked over this paperwork. I just confirmed the support for the prior conviction, finding probable cause, setting your bond at $5,000. That's the standard for a third-degree felony, making it a condition of pretrial release. If you post that bond, immediately check in with pretrial services, sign up in person, calling them on Wednesdays, all the standard conditions plus special conditions 16, 17, and 18, which says you can't have weapons or firearms in your possession. You can't have any intentional contact with the listed victim. Stay 500 feet away from her home and her vehicles or where she works. And you get to go back there one time with the police within 48 hours to get your stuff, things like medicine and clothing. Have a nice day, ma'am. Tiffany Witten. Ma'am,
Yes,
you
sir.
failed to appear for jury selection on a charge
Yes.
of misuse of the 911 system. You already have a private attorney. It looks like
Yep.
Jay McNeil. Okay, you already have an attorney.
Yes, sir.
Finding probable cause, because I'm looking at Judge Stacy Taylor's bench warrant. She wants you held no bond. We'll hold you no bond. And it looks like you're going to have court next on May the 28th. Have a great day.
Thank you.
Bet. Folks, give me 1 second. I got something I got to attend to real quick. And then if anybody needs a water break, this might be a good time. Give me just 1 second to do something that's waiting. All right, sorry, everybody, my apologies. I always tell folks, as judges, we're on call like doctors. So every day of the year, even Christmas, some judge has got to carry a phone around with him. And when the phone rings or something, the judge needs to give immediate attention, and today's my lucky day. So my apologies about making y'all wait. All right, let's turn to the gentleman. Next up is Carlos Verrocchio Mendoza.
Greetings, Your Honor.
Good afternoon, sir. You're here on 3 new charges, and then you have a warrantless VOP out of Volusia County. I can't give you an attorney for the Volusia County charge, the VOP, but if you want me to appoint the public defender for the DUI property damage and refusal to submit to a DUI, the local charges, I will.
Yes, Your Honor. But you said I do have an opportunity to get an attorney later, a private attorney later?
Yeah, no, you absolutely. It's like a two-way street. If you want me to appoint the public defender on the local charges, I'll provisionally do that. Or if you want to, since I can't appoint I can't give you an attorney for the Volusia thing, you might want to hire one attorney to handle everything. If you want to explore that, yeah, you could, if you want to look into that, you can always ask for a public defender later. Or if you want the public defender right now on the 3 local charges, I'll do it.
Yeah, let's just start with right now, public defenders, Your Honor.
Sure, I'll provisionally appoint them to represent you. I've looked over the Lakeland Police Department affidavit along with the citations, also recognizing that you have that probation matter out of Volusia County. Finding probable cause for these 3 charges, setting your bond. Let me just look at the citations real quick. Now set your bond at 2,000 cash or surety on each of the 3 local charges, and I'll hold you no bond on the VOP. Your court date for the local charges is going to be on May the 15th. Polk won't call Volusia and tell them to come get you until you've either bonded out or resolved the local charges. Once you've done that, then they'll call Volusia and tell them they're free to come get you. Have a great day, sir.
Thank you, Your Honor.
Yeah, Lemoyne Nathan Duncan.
That's to be heard on this one, Judge.
Sure. Mr. Duncan, you're charged with petty theft, burglary of a dwelling, and criminal mischief. You want the public defender?
Yes, sir. I'd appreciate it.
All right, I'll go ahead and appoint the public defender to represent you. I've looked over the Polk County Sheriff's Office affidavit, and I find probable cause for all 3 charges. Mr. Matthews, you wish to be heard as it relates to bonds?
Yes, Your Honor. With regard to the burglary of a dwelling, that is an enumerated dangerous offense. In this case, I am filing a motion for pretrial detention, providing a hard copy to appointed counsel. May I approach?
Yes, sir.
Providing the original to the court. Respectfully request the court review that motion, and if the court finds it facially sufficient, that the accused be held no bond on that count pending a hearing on my motion, which should be set next Monday, May 4th, at 1 o'clock on the A2 docket. Thank you.
Ms. Smith, anything from the defense?
I'll just defer to the court.
All right. Mr. Duncan, I'm looking at a document that's been titled a motion for pretrial detention. It's filed pursuant to both Florida Rule of Criminal Procedure and the Florida statute section 907.041 5C5. After reviewing this 2-page document, I believe that it's facially and legally sufficient. So as a result of this, I am going to hold you no bond on the charge of burglary of a dwelling. Now, you'll go in front of the judge, the circuit judge, next week on the 4th to have a hearing on that charge. On the other 2 charges, I will set you a bond. On the criminal mischief, having found probable cause, it'll be $5,000. And on the petty theft, I think a $1,000 bond is appropriate. I'm going to make these bonds conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, and call that office on Monday. Well, let's do Tuesday, Thursday. Let's do Tuesday, Thursday. You have all the standard conditions everyone else has, plus the following special conditions. You can't use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're not allowed to have any intentional contact with the listed victim. Stay 500 feet away from the victim as well as their home, vehicles, place of employment, and school. You also cannot go within 500 feet of the event location, the home that was allegedly burglarized and damaged. Step to your left, sir. William Green.
Sandra Smith, Public Defender's Office, Your Honor. The pretrial release had contacted the alleged victim, and she does want to have contact with him. I believe she may be here. She's here. And she doesn't want to press charges and says there was no physical altercation. And I believe she may want to be heard by the court.
I'll ask to be heard as well.
Sure. All right, sir. Mr. Green, you are charged with domestic violence battery.
Yes,
You
sir.
want me to appoint the public defender, or instead, are you planning on hiring a lawyer that you get to pick?
Public defender.
All right, I'll go ahead and provisionally appoint that office to represent you. I have looked over this affidavit. I read it back in my office. I'll just take a look again and jog my memory. Sir, I've looked over the affidavit, finding probable cause for the charge. Let me take a look. I've already reviewed it, but sir, for you to know, anytime someone's charged with a domestic pretrial services, Ms. Amber's here today representing that office. They try to reach out to the alleged victims and find out what the victim wants me to know. They ask a series of questions. I certainly will read those ahead of time. So I'm just jogging my memory from my earlier reading. What I'm being told is that the alleged victim does not object to you getting out of jail, that she wishes to have contact with you, that she's not seeking a restraining order. She indicates no prior or previous violence. She doesn't fear any future violence. You don't possess any weapons. She acknowledges that you reside together, and she does not object to you returning home.
Yes, sir.
Ma'am, you want to be heard? Come on up. Yeah.
Run up here to the podium, please.
If you want to, raise your right hand just so we can make it official. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, sir, I do.
You put your hand down. Tell me your name.
Teacher Green.
Ms. Green, you're the alleged victim. Go ahead and tell me what you want me to know.
So I have currently filed a motion for dismissal. Again, I'm not sure if I'm even doing my process right, but I'm doing the best I can with this. I am the alleged victim. I am asking the honorable court to dismiss the case. My husband was arrested on the 27th. Prior to the arrest, I clearly advised the deputies that nothing physical, no physical altercation had happened, no battery, no touch strike, whatever the definition is. As the alleged victim had no injuries and the deputies documented no visible marks at the scene. Alleged victim signed a sworn affidavit at the scene after I was denied to be able to sign one. Any contact between parties did not constitute violence or a criminal conduct or any form of domestic violence. The minor child at the time of the incident, or whatever you would call that, was questioned and confirmed that there was no altercation and no striking or physical altercation. The allegations leading to arrest originated from a third-party neighbor who was not present at the time, nor were they capable of having a clear or direct view over to our house, as they were across the street and behind bushes.
Despite being advised of these facts, the officers proceeded with their arrest without further investigation into the accuracy of the allegations or the statement of the alleged victim. While Florida domestic violence protocol may guide officer response, such protocol does not override the requirement that probable cause be supported by facts and evidence. Based on the sworn affidavit of alleged victim, the corresponding statement of the minor witness, absence of injury, and lack of evidence supporting domestic violence or battery, probable cause is insufficient, in my opinion. Alleged victim is not in fear for her safety, does not consider any contact from the defendant, William Green, unwanted, and does not wish to pursue charges. This matter is currently under review, including concerns regarding deputies' conduct with Internal Affairs, Polk County Sheriff's Office, by a Lieutenant Thomas. To proceed with charges under these circumstances diverts resources from legitimate cases involving actual victims of domestic violence, which I was when I was younger. So I do know what domestic violence is. I was a very severe, extreme victim of domestic violence. And then I also have created my own waiver of prosecution because I could not get the state's attorney office to allow me to sign one for them. And what I have said is kind of just a repeat of what I went over. I sign it freely. Nobody is forcing me to do any of this, and I am not in fear of my life, my safety, or even my sanity.
Use anything from the state?
On the one hand, Judge, I would acknowledge, I have not spoken with the named victim directly, but I have received communication from others in my office indicating she's contacted our office a number of times. It appears our office has offered to sign her up with the domestic violence class and waiver process. I'm not directly involved in that process. So I do acknowledge that. I would also ask the court to consider, now that it's found probable cause, in the last felony case involving the defendant, I pulled his score sheet. That was a 2023 case. It looks like the history there on the score sheet was grant theft firearm, uttering a forgery, attempted burglary of a dwelling, 4 counts of felony petty theft, 2 counts of possession of methamphetamine, and 14 other convictions for misdemeanors. I did not run a full CCIS for the purposes of first appearance, but so the state would ask you to, of course, I think it's appropriate to take into consideration what the victim has to say. The state would also take the position that it is appropriate for the court to consider criminal history. Thank you, sir.
That is also a very incorrect timeline. Me and yes, my husband used to be a criminal. Nobody is going to deny that. He has been out of trouble for a very long time. The last time, the 2023 case, what he was arrested for, and finally, for the first time in his life, completed probation, was a failure to return leased property. The guns had happened multiple years before that. I believe 6 to 8 years prior to that. My husband has not been in trouble in a very long time, and I request the state and the judge to take into consideration that what doing things like these to these criminals when they finally get out and turn their lives around is what sends them directly back into the system.
Okay, real quick, I always tell folks, I heard what you had to say. I read the affidavit. I wasn't there. I'm not going to swear if something happened. I didn't see it. If I was there and I saw it, like allegedly the neighbor across the street, then I couldn't be the judge because I'd be a witness. You can't be both. So I just want you to know that I'm not saying that, oh, it happened this way. I'm not saying it happened the way you're saying. I don't know.
Yes, sir. I do understand.
My role is not to conduct a trial today. I always tell people for the state to prevail at trial, it's a very high hurdle they have to accomplish and overcome beyond to the exclusion of every reasonable doubt. What's needed for today, the probable cause is not here, it's way lower, okay? And I'm supposed to review the 4 corners of the document to make sure that all the T's are crossed and the I's dotted, that the allegations meet all the elements of the charges. Not that it's, I'm not making it rubber stamping that it's true. I'm just saying true or not, they've alleged that it happened and it's in this document. So that is what I'm doing, and that's where I came up with the probable cause. The neighbor across the street, and I don't know if you've had access to this or not.
No, sir, I have not. They just gave me permission a couple minutes ago.
Yeah, just letting you know, I've never read it. I know if you didn't, wasn't sure if you did or didn't know what was in it. But it says, paraphrasing, or I can even, it's pretty short. Someone, an eyewitness across the street advised they were sitting outside the residence and observed and the suspect in a verbal altercation that became physical when the suspect struck the victim with his right hand in an unknown position against the victim's will. At least that's through his eyes. That whether it was against your will or not, would probably have to be something that you would have to answer.
So I have had, we just finished prior issues with the specific neighbor Kermit across the street. I had also notified deputies of that at the time. They did not come out of their household or anything else to be even capable of writing that statement, truthfully, until the officers arrived.
So the witness advised that the suspect hit the victim in the arm when the victim attempted to get her phone back. Then I read down further, the police officers made contact with the suspect, who advised that he and the victim were in a verbal altercation over his mental health status and their current issues in court. The suspect advised that no physical contact occurred during the altercation. Here's the important. The suspect advised that he did physically take the victim's phone from her during the initial altercation.
Yes, sir.
Therefore
And-
committing the act of domestic. Just letting you know I've read.
Yes, sir. And I did notify pretrial as well that that happened inside the house. And when he had snatched the phone was sitting on the table. Now there was another time where they were stating that because I reached into his pocket to grab the phone and he jumped and grabbed the phone. But none of that was unwanted. None of it was unwarranted. And any touch by the defendant to the alleged victim is and will always be wanted.
So what I'm going to do, having found probable cause, I'm going to set his bond at $1,000.
I request him to be ROR'd.
You can request it, but I'm going to tell you no. Candidly, a domestic battery normally is higher than one. Typically, you've been sitting here long enough to see it. There's a lot of $5,000 bonds
Yes, sir.
that have been given
I do
today.
at least appreciate it.
Yeah, and that's why I didn't want to be snippy. I would just say, you can ask for it. I just wanted to let you know you might not get what you asked for. And I did factor in, I think I would be, I'm not saying he did it once, he'll do it again. But he does have, pretrial has told me he has an extensive prior criminal history. That does factor in a little bit to the point of,
Yes, sir.
is he likely to come back? Is he likely to not come back? You heard me say earlier that.
Oh,
I'm gonna set the bond at $1,000, which is, candidly, it's a bond that you would get for a simple battery, not a domestic, an M1. I'm gonna make that bond a condition of pretrial release. So if he bonds out, I want him to sign up for pretrial services. Call them on Wednesdays, one time a week. He has all the standard conditions everybody has, which are things like don't commit crimes, don't drive without a license. And the special conditions he has are keep you safe, in abundance of caution. I don't want him to have any weapons, firearms, ammunition, or knives while he's on pretrial. And although you want him to have contact, I'm going to go along with what you say. I'm going to allow him to have contact with you, but this contact is prohibited from being physically or verbally threatening. He can't be violent or abusive in any manner. We call that peaceful contact.
Yes, sir.
No screaming, yelling, threatening, any of that stuff. That'll cause you to violate pretrial. He'll be hauled back in with a new charge and probably be held against, with no bond.
Our household itself is very loud. We have four minor children, and it is a mobile home with walls, so everything is loud in our house. My husband isn't a violent man, and I do just want that.
Sure. No, like I said, I think but for you being here, and but for you saying what you said, I would not have allowed contact, and the bond most likely would not be as low as it is.
And I,
Good day, man.
all Steve.
All right, next up, we have Timothy Hankins. Mr. Hankins, you're charged with domestic violence battery with a prior conviction. That makes it a felony. You want the public defender?
Yes, sir.
I'll appoint the public defender. I looked over the Lincoln PD affidavit. Improbable cause.
All right, it's all on the ground.
making it a condition of pretrial release. If you're able to post that bond, immediately check in with pretrial services, sign up in person, calling them on Tuesdays and Thursdays since it's a felony. You have all the standard conditions everyone else has. It does look like y'all have the same address, so I'll do 18. 16 says no weapons or firearms can be possessed. 17 says no intentional contact with the victim. Stay 500 feet away from the victim, their home, their vehicles, and where they work. And you get to go back to that home one time with the police within 48 hours to retrieve your essential items. Have a great day, sir. Myron Hardy, charged with domestic violence battery. Sir, do you want me to appoint the public defender? Myron Hardy.
Sir?
Want me to appoint the public defender?
Yeah, you can.
I'll appoint the public defender. Looked over your paperwork, finding probable cause, setting your bond at $2,500, making it a condition of pretrial release. If you post bond, immediately check in with pretrial services, sign up in person, calling them on Wednesdays, all the standard conditions plus special conditions, 16, 17, 18, no weapons or firearms can be possessed, no intentional contact with the victim, stay 500 feet away from the victim as well as their home, vehicle, and place of employment. And you get to go back one time with the police within 20 or 48 hours, from getting out of jail, accompanied by them so you can retrieve your essential items like medicine and clothing. Have a great day, sir. Dylan Ray Hartman. Mr. Hartman, you're charged with domestic battery and resisting an officer without violence. Do you want me to appoint the public defender?
Yes, please.
I'll appoint him. Looked over your affidavit. There is probable cause. I'm going to set your bond at $2,000 on the domestic battery. Going to set it at $1,000 on the resisting without. If you're able to post bond, immediately check in with pretrial, sign up in person, calling that office on Wednesdays, all the standard conditions that everyone has, plus the following special conditions. You have not allowed to have weapons, firearms, ammunition, or knives in your possession, and you're not allowed to have any intentional contact with a listed victim. Stay 500 feet away from the victim as well as their home, vehicles, and place of employment. Have a great day, sir. Thanks, Dave. Have a great day. Arturo Javier Felipe Huerta.
Yes, sir.
Are you been charged with possession of methamphetamine and possession of drug paraphernalia? Do you want the public defender?
Yes, sir.
I'll go ahead and appoint them to represent you. Finding probable cause, your bond on the meth is $5,000. Your bond on the paraphernalia is $1,000. Have a great day, sir. Oscura Lavoy Rivera.
Sandra Smith, Public Defender's Office.
Yes.
I do have a
Good evening, Your Honor.
I do have a stipulation with the state regarding his charge, that there's probable cause for a lesser charge, just a petty theft secondary misdemeanor, as the amount taken was alleged to be taken was only $20, and in lieu of the first degree misdemeanor that he's charged with at the moment.
Okay. Mr. LeBoy, you're charged with petty theft. As you stand there, it's charged as petty theft, retail theft from a merchant in an amount greater than $100.
Yes,
Do you
sir.
want me to appoint the public defender?
I guess, yes.
I'll appoint the public defender to represent you. Sir, I've looked over this affidavit from the Lake Wells Police Department. Heard
Yes,
the
sir.
argument and stipulation of the parties. I am going to
Yes.
find probable cause for the M2 retail petty theft.
Okay.
Now, I do see that you're currently open on a diversion case.
Yes, I have a diversion, sorry.
Yeah, I know that, Smith. I'm just,
Mr. LeBoy, Sandra Smith, Public Defender's Office. His bonds have been discharged on that case back on April 14th. That's a couple weeks ago. So it's he's not under any bond to revoke.
yes, ma'am, I didn't revoke it.
Okay, I was
telling
going to
you.
object to that if you were.
You can object when I'm done or when I'm not doing it. I prefer that you not interrupt me when I'm telling him
Sorry.
what he has. I think I have every right to take into consideration that he has been charged with a crime and that he's going through diversion. And I'm telling him that because I'm about to increase your bond because I think that that should be a part of it. Now, had I revoked his bond, you have every right to jump up and say, Judge, you can't do that. And I'd say, you're right, I can't do that. But I have every right, I believe, to take into consideration that you have an open case that the bonds have been discharged. So I'm going to do that. I'm telling you that I recognize your diversion case, setting your bond at $1,000. Have a great day, sir.
Wait, but,
Yeah, Ms. Smith, like I said, I tried real hard. And Ms. Leatherwood does a great job of helping me wrestle with the issues. I'm not saying I'm perfect, but when I get it wrong, yeah, jump up there and tell me. Sounds like you anticipated I was.
I thought you were going to par from, I apologize.
No, no,
I thought you were going to.
Yeah, no, so I'm saying you anticipated I was going to do it, so you jumped up and told me I can't do it, when really I knew I couldn't do it. I was just telling him why his bonds was getting enhanced. So next up is James Lane.
yes, sir.
Mr. Lane, you're charged with trespass on property other than a structure or a conveyance. You want
Yes,
me to
sir.
appoint the public defender?
Yes, sir.
All right, I'll go ahead and appoint the public defender to represent you. I've looked over the City of Lakeland Police Department affidavit. I find probable cause setting your bond at $1,000. Have a great day, sir. Levi Wade Lassiter.
Yes, sir.
Mr. Lassiter, you're charged with a warrant out of another jurisdiction, Hernando County, on a charge of battery by strangulation. I cannot appoint a public defender because charge is out of Hernando. You can
Yes,
hire
sir.
a private lawyer if you want, or you can wait till you get back to Hernando and ask for a public defender once you get back there from a judge back there. I'm looking over your paperwork. Looks like there's a judge over there that issued the warrant out of Hernando and wants you to be held no bond. So we'll hold you no bond. And if there's nothing else holding you in jail here, we'll notify them to come get you. And if for some reason haven't been picked up by a week from today on the 6th, we'll bring you back so you can talk it over with the judge. Have a great day, sir.
Yes, sir. You will.
Next up is Sterling Mack.
Yes,
Mr.
sir.
Mack, you have 1, 2, 3, 4, 5, 6 different VOPs, all out of Hillsborough County. I'm not allowed to appoint the public defender for a Hillsborough County VOP. Looks like you're being supervised here in Polk, but the cases are in Hillsborough. You can hire a lawyer now or wait till you get back to Tampa and ask for a public defender. Finding probable cause because the probation officer alleges that you tested positive for cocaine while on probation. I'm going to hold you no bond, and if there's nothing holding you from us in the way of local charges, we'll notify Hillsborough they can come get you. And if you're still here on May 6th, we'll bring you back to talk it over with the judge. Have a great day. Preston McLean.
Sanderson, Defender's
Yes, Your Honor.
I just want to weigh the reading of the charge he's here for violating his probation on from Brevard County.
All right, sir, you're here on a VOP out of Brevard County. It's for a felony offense. I cannot appoint the public defender, but you can certainly hire a lawyer or ask for the public defender once you get back over to Brevard. I've looked over the paperwork. It looks like there's a Judge Crawford involved with your case. Judge Crawford, find probable cause, and Judge Crawford wants you held no bond. We'll hold you no bond and we'll notify them you're available for pickup. If you're still here a week from today, we'll bring you back so you can discuss it with the judge. Have a great day.
All right.
Hershey Lamar Roberts.
Sanderson, Defender's office. The alleged victim does want to have contact with him, so he's going to ask for no violent contact with the alleged victim.
Mr. Roberts, you are charged with domestic violence battery. Do you want the public defender?
Yeah.
I'll appoint him. Looked over your Bartow Police Department affidavit. I find probable cause for the charge. Taking everything into consideration, I'm setting your bond at $1,000, making it a condition of pretrial release. If you're able to post those bonds, that bond, immediately check in with that office, sign up in person, calling them on Wednesdays, all the standard conditions plus special conditions 16 and 20. You can't have any weapons or firearms or ammunition in your possession, and you are allowed to have contact with the listed victim. This contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever. Have a great day, sir. Brandon Farouk Ruiz Mejia.
Yes, Your Honor.
Sir, you're charged with reckless driving. You're also charged with DUI with property damage, and it looks like a third charge of DUI with a breath alcohol reading greater than a 0.15. It does appear as though all these charges have been bumped up 1 degree based upon what's been alleged as your unlawful entry into this country. Do you want me to appoint the public defender to represent you?
I have a private attorney, Your Honor.
Fair enough. You're absolutely able to hire a private lawyer. If if you change your mind or something goes south with that, you can always ask for a public defender later. Sir, I've looked over the paperwork. I will tell you, because of the allegation that you're here unlawfully, it does cause the charges to be elevated. So 2 of these 3 charges are identified as felonies. The DUI with property damage normally is an M1. 1 notch up is an F3, so that's a felony. I find probable cause for the DUI with property damage. Your bond is $5,000. The reckless driving with damage to persons or property also gets bumped up 1 degree, which makes it a 3rd degree felony. The bond is $5,000. And lastly, a normal DUI with a 0.15 is an M2, punishable up to 9 months in jail. 1 notch up and puts you at an M1, so it's 1,000. You add those 3 together, it's a total of $11,000 cash or surety. And because you currently right now have a hold from ICE, I am going to ask the clerks to prepare a detainer that I'm going to sign. Have a great day, sir.
Thank you.
You bet. And we're up to John Torres Garcia.
Yes, sir.
My understanding is the alleged victim wants to have contact with him, so he's going to ask for no violent contact with the alleged victim.
Mr. Torres, you're charged
Yes.
with resisting without violence. You're also charged with domestic violence battery. Do you want me to appoint the public defender to represent you?
Yes, sir.
All right, I'll go ahead and appoint that office to represent you. I have reviewed the sheriff's affidavit and I do find probable cause. Let me take a quick look. I want to make sure I feel comfortable with what Ms. Smith is asking for. I will tell you I had some concern because question number 8, the alleged victim, when asked, do you object to the defendant returning home? She declined or was unsure how to answer that question. So that gives me a little pause. Mr. Matthews, you have any position on that, on whether I should allow contact or not between her, the victim, and alleged defendant?
No, Your Honor. Thank you.
Just want to give you a chance.
I appreciate it, sir.
Yeah. This, just so you know, the allegation is that you open hand smacked the alleged victim across the right side of her face with your
Yes, sir.
left hand. Now, don't
Yes,
talk
sir.
about it, just let me know what the allegation is, what's in front of me. Says that the allegation is you threw the victim's cell phone into the bathroom, where you continued attacking her by pushing her upon her chest 3 times, causing her to fall backwards into the bathtub, causing abrasions on her left arm. The policeman observed redness on her left side of her face. So what I'm going to do is I'm going to set your bond at $5,000 and make it a condition of pretrial release. I'm going to set your bond at $1,000 on resisting and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person and call them on Wednesdays, all the standard conditions. Plus, special condition 16, do not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. Ms. Smith, I'm a little conflicted on this one. I think in an abundance of caution, I'm just going to do condition 17 and give him a chance, if he chooses to get in front of the judge he's assigned to, maybe she'd be available to come in and make her feelings known because it's a little ambiguous there. So I'm going to Order that you have no intentional contact with the listed victim. Stay 500 feet away from her, her home, her vehicles, where she works, or where she goes to school. And because she resided with her prior to being arrested, you get to go back there one time within 48 hours of your release from custody, accompanied by the police to retrieve your essential items. Have a great day, sir.
So let's go.
All right, deputies, thank you for all your help. Have a great rest of your day.
Yes, sir, have a good day. Good morning.
Hi, good morning. I'm still waiting for him, but
Okay.
he's already aware, okay?
Thank you.
You're welcome.
Hey, good morning. Hey, can you let me know where this email located at 42913? This beers? Oh, okay. Oh, I didn't hear it. Oh, no English over here. I'm progressive. It's 42913. Okay, thank you. Bring one to Weston. Send me 14 cell call to video board. You copy? Oh, man. He's coming, man. I called him about 15 minutes ago and he's still not here.
That's okay. Thank you. I appreciate it.
Leroy. Copy. Alicia, do you let him? Solo que esté waiting for him, that he needs to be ready. He's refusing. So he's not coming? All right, so I'll let them know then. All right. Ma'am, I guess he's refusing.
So he's refusing to attend this hearing and he knows it's a parole hearing?
Yeah, do you want me to go, and to have an officer go get him? That he have to?
I mean, he has the right to refuse if he wants to
Okay.
refuse. I just want to make sure he knows that he's refusing his parole hearing. And
Do you
so
want me
you're-
to pass that message to him before, it's official that he refused?
yes, can you just have the officer say that, ask if he is requesting to either waive his hearing or is he just not gonna appear?
Okay, give me a minute.
Thank you so much.
You're welcome. Hey, Alicia, can you let him know that right now he refusing his parole here? He's sure about that. And let me know because they're still waiting. All right, copy. Coming? All right. It's on me, ma'am.
So he wants to waive the hearing? He won't appear?
No, he's coming. He's
Oh,
coming.
he's coming. Okay.
Yes. All
All
right.
right. Thank you.
You're welcome.
Hey, Mr. Monji, I'm doing court, right now, so I'll go later. All right, thank you. Bye.
Voy a tratar de bregar toda esa situación. Voy a es guiar, pero no puedo guiar porque no tengo día, tengo un Instagram. De los planes, voy a probar.
Bien, pues esos son buenos planes para tener. Pues ya saben, no bien sin licencia. Aquí no hay que poner lo que llaman el
Do you want to west too? That's 7 easy route. On his way.
Thank you.
If I wouldn't have another email here, I would have go got him myself, but
No, I appreciate it.
I don't want to make you wait. All right, thanks.
No, it's okay.
Hay veces que a la gente le ponemos el grillete. Le ponemos el grillete cuando hacen las cosas que no tienen que hacer y eso puede ser. Y eso pasa. Luego puede y si aquí te pusieron con eso, entonces, ambulando.
Morning, Mr. Hall.
Morning.
Morning. I know that you had listed on your sheet that you wanted to waive the preliminary hearing. Do you still want to do that?
I mean, I don't know. It sounds like if the evidence looks like it's going to be deemed as a violation anyway. So it was like, what's the point?
Well, it's up to you. I mean, you have the right to, if you'd like to waive. I just needed to talk to you to see if you would like to waive or not.
But I don't know.
It's up to you. You can move forward with the hearing or you can waive the preliminary hearing.
What about the revocation hearing?
It would go
Okay.
to a rep hearing if I deemed it necessary.
Do you deem it necessary?
Well, I haven't done the hearing. So you can, I mean, either way, I'm gonna say my, what my choice is. If you waive, I still say what's gonna happen. If you decide to move forward, we still say what's gonna happen. So it's up to you.
I waive it. Go ahead.
Okay, so I'll go on the record then, and I'll accept your waiver on the record for today. So regarding Paul Donnell, number 429-139, today's date is April 29th, 2026. Sir, can you just state your name and inmate number?
Darnell Hall, 429-139.
Okay, so the offender's requesting to waive the preliminary hearing. So I will accept your waiver, and I will schedule you for a revocation hearing. So what's gonna happen is, we have 60 days from your return to custody to schedule you for the rev hearing. So I will schedule that, and then you'll get notification of that when that is, and you're gonna get a summary of my findings from today's prelim. Okay? So that at that point, that's when we discuss things, your release plans, things like that. We talk about that. Anything you want to say in regards to the charges? If you did, you're gonna have an opportunity to at the rev hearing too. Okay?
Okay.
So I'll schedule you soon, and I will see you soon for that hearing.
Alrighty.
Okay, you're all set, sir.
Thank you.
Okay, have a good day.
Too.
Oh, yeah, it's right there.
Good morning.
Morning.
Hi, Ramo.
How you doing? Who's that? Hey,
Hi. Hey. Good morning, sir. We're just waiting for your attorney to join. So when he joins, we can get started, okay?
Fair enough.
Good morning, Attorney Urso. It is *6 to unmute. Looks like you're having some trouble, so I'm gonna hang up and then have Teams call you back directly.
Good morning. My apologies. I couldn't set up the, it wouldn't work on the email.
That's okay, I can hear you now. Can you hear me okay?
Yes, I do. Thank you.
Oh, perfect. Okay, so we will get started then with Mr. Ponger's preliminary hearing.
Okay. We will stipulate to the probable cause because there was a probable cause finding in the court.
Okay. So good morning, I'm P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Ponger Joseph, number 424547. Today's April 29th, 2026. This hearing is being conducted via video at the BOPP Central Office in Bridgeport Correctional Center. This is a public hearing and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
It is Joseph Ponger, 424547.
And we have counsel here today. Can you please identify yourself?
Good morning. Lindy Urso for Mr. Ponger.
This is a preliminary hearing, which is the purposes under Connecticut law. It's to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means release you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge the state your appeal is bringing against you, and we will review and identify exhibits filed for the record. Counsel will then have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
I do not.
Okay, you have important rights today, the right to have an attorney present, and you have counsel here today. You have a right to receive the written notice that charges the violation. Did you receive the written notice?
I did.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
I do.
All right, so we're going to review the charge the state your parole officer is bringing against you and information underlying each charge. So the charge one, obey all laws, obedience to the law. Your charging officer reported on 4/11/26, you're found to be highly intoxicated on alcohol, verbally aggressive, and behaving in a disorderly manner at a local bar establishment in Stamford, Connecticut by members of the Stamford PD. Based on your actions, you were arrested by members of the Stamford PD, which violates parole condition 2, obey all laws. And the state filed the following exhibits that were pre-marked as Exhibit A, CT conditions of parole, B, CT board of parole remand to custody order, C, notice of parole violation, D, parole violation report, E, Stamford police report, and F was parolee rights. Did you receive notice of parole violation report, and those other documents that I marked, and did you review them?
I did.
And defense counsel has filed the following exhibits that were pre-marked for identification. Defense Exhibit 1, which is the court letter that was received, and Exhibit 2, which is a certified copy of the disposition from court. I will put on the record the disposition from court did show that these charges were disposed on 4/24/26. They were subbed down to creating a public disturbance, and you were issued a fine. So that was an infraction that it was subbed down to. Do you need to continue this hearing to obtain any additional evidence?
I do not.
No.
Okay, we have no witnesses today. So it is the defense's opportunity. If you'd like to respond or go ahead.
Oh, I'm sorry. No, I had submitted, I meant to submit letters in one of the emails yesterday, and in the afternoon I realized the letters I didn't attach. I then resent them. It doesn't sound like they made it into the record. They're just character letters and work letters. I sent them yesterday, trying to find the time I sent them. Because I had said attached our letters and the certified copy disposition, and when I went back and I saw the exhibits, I said the letters weren't there, and I checked my email. I forgot to attach the letter part. So I sent to Yenny yesterday at 6:08 p.m., so she probably didn't get it this morning.
Probably not. I didn't receive anything yet. Do you want to say anything in regards to the letters or?
Well, they're just letters and they talk mostly about his work ethic. He's a plumber and he works for his dad's company. His dad has, he's disabled. His dad's lost several toes. I think it's diabetes. And, so Joe is, he's a real hard worker and he's the key part of the business. The business is not going to last with him not there, but that's kind of what that, and the letters are just talking about what a nice guy he is generally. And sorry, I gotta get away from this leaf blower. I didn't make it into the office. Sorry.
That's good.
So that's the gist of the letters. So you want me to just address everything right now?
Yes, now is your opportunity if you'd like to address probable cause. I know that you did mention that you are conceding probable cause, so. If you
Yeah,
wanna
I read
say
according to the.
Good.
Yeah, according to the regulations, your regular BOP parole regulations, if there's a finding of probable cause by the court, that's binding, and there was a finding of probable cause, so we will concede that there was probable cause.
Would you like to say anything in regards to the severity of the allegations before I announce my findings?
Yes, a couple of things. One, there's a reference to a racial slur in there. Just for the record, everybody involved was white. That was my understanding. It was the colloquial NIGGA. You know, some people use that term to refer to anybody. It wasn't used in a race. There were no African American people involved. And I just say that because when people see that word, it looks terrible, but it wasn't used in that kind of context. Secondly, as I was indicating with the letters, this is completely out of character for Joe. He doesn't generally drink either. He knows better. I don't know what he was thinking this night, but that was the issue. And I know he has, his father and him had a $50,000 plumbing job starting that Monday, which has been on hold obviously now while Joe's locked up because the father can't do it. What else? Joe, there's one other thing I wanted to mention. The person that he struck at the bar, Joe doesn't really remember much, but the person he struck at the bar literally came to court at the arraignment to speak on his behalf because he knew Joe's father and he didn't want to jam. He felt bad about Joe getting jammed up. He knows he's a good kid and that he was just, in his wrong frame of mind. So that gentleman, that's how we got it. They would have dropped it to this creating public disturbance the day of the arraignment, but the prosecutor he was a newer prosecutor, just wasn't comfortable. So he gave me a week continuance and then he did it. He didn't want to do it at arraignment. But so, the person involved literally came to court and spoke on his behalf. And overall, I know the hearing officer has discretion. I saw the recommendation for the TOP program, which I understand I think is an in-facility, it's like a 60-day program is what I heard. But my hope and my request is that the court, and that's why I provided a treatment provider. You got that letter, right? The aromatherapy letter? Yes.
Yes.
Because I checked on his availability, the aromatherapy, Robert DeRoma, and he said he could see him as soon as early next week. So it was my hope that given, Joe's, I think it's been a couple of years on special parole where he's done well, and parole, maybe longer. He's working. This is a clear, it's a one-off idiotic. He should not be drinking. That's the bottom line. And I think if I would request, especially, it's not so much that Joe can't do 2 months. He did a 5-year jail sentence. It's a question of the business. There's literally big jobs that are in jeopardy, and if he doesn't get out in another couple of months, it's going to be devastating. And because the issue is alcohol clearly, and we have treatment set up in place ready for him outpatient when he comes out. That's why we're requesting, a little unusual, but I don't think we don't think it's necessary that he stay in to do the treatment. We ask that he be released and be able to do the treatment outpatient under supervision.
Right. Thank you. I appreciate all those comments. And do you have a residence that you're residing at? Is it your own residence or?
I currently have my own apartment still, yes.
Okay. Is there anything else before I announce my findings?
One other thing I just wanted to, hold on, Joe. One other thing I wanted to point out, sorry, is For what it's worth, this is what the officers told me, because I came to see Joe the day he was arrested. It was over the weekend. And the sergeant on duty said that initially his parole officer had told them just release him, but then he went through this, the supervisor had put the nix on that and told him he's got to remand him, but just for whatever that's worth.
Okay, thank you. Mr. Conger, if you do want to speak, I just need to swear you in under oath first. So would you like to speak today?
No, I'm all right.
Okay. So I do acknowledge you were on special parole supervision for approximately 3 years and 5 months before you returned to custody for this incident. And I've listened to everything that your attorney stated. I don't see any issues you had prior on supervision. There's no prior violations. There's no issued misconducts that you've received or anything like that. And I do appreciate the additional evidence regarding what happened in court. So I'm going to announce my findings. So I do make a finding of probable cause. Charge 1, obey all laws, obedience to the law. This is based on the evidence that was provided, which is exhibits A and E, as well as you did have a conviction in court for a sub down, which is an infraction now. But I do find that behavior meets the elements. However, I find the acts are not serious enough to warrant revocation. As such, your parole will be reinstated. The records office at the facility, as well as your parole officer, will be notified. So I'm going to reinstate your parole today. I am going to recommend to your officer that they add a no alcohol stipulation, that they request it from the board to add that. I think you know what you need to work on out there, and that you get involved in treatment. So that's going to conclude your hearing, and you will be released today.
Thank you, ma'am.
All right.
Thank you so much.
Thank you, Attorney Urtel.
Thank you very much. We appreciate that. Thank you so much.
All right. Have a good day.
Thank
You're all
you.
set, sir.
Well,
Good morning.
And how are you?
Good.
Maldonado?
Yes, please. Good morning, sir. We're here today for your preliminary hearing, so we're gonna get started with that, okay?
Yes, ma'am.
Good morning, I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Maldonado Jacob, number 399372. Today is April 29th, 2026. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Jacob Maldonado, 399372.
And you have counsel here today? Please identify yourself.
Good morning, Peter Matthews with the Public Defender's Office for Mr. Maldonado.
This is a preliminary hearing, which the purposes under Connecticut law is to determine if there is probable cause to believe you've committed an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means at least place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge, the state your PO is bringing against you. I will review and identify exhibit file for the record. Counsel will then have an opportunity to adjust the issue of probable cause to the severity of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, important rights today, the right to have an attorney present, and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yeah, I guess they went on based on the police report because I did.
That's just the notice that parole served you. They gave you that notice saying why you're in jail. Okay.
Yes.
So you have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case at the hearing. You have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am.
Okay, so you'll now review the charge, state your appeal is bringing against you, and the information underlying each charge. So charge one under bail laws will be into the law. You're charging officer report on 3/20/26, approximately 22:45 hours. Officers from the Meriden Police Department responded to Stower Drive on a report of a dispute involving a large crowd of people in a parking lot and one shot fired. When officers arrived at the scene, it appeared that you and all involved individuals were no longer in the area. Officers collected video footage of the incident and you were identified as the male who fired the shot and left the scene in a red sedan. Meriden Police Department were able to identify you with Jacob Maldonado. On 3/27/26, you told the detective of Meriden Police Department that you're at the location, had an argument with your brother, Demetrius Maldonado, and his girlfriend, Godbow. After further investigation, Meriden Police Department had a probable cause to believe you had a gun and fired a shot on 3/20/26. As a result of the findings, Meriden Police Department applied for an arrest warrant, which was granted on 4/7/26, charging you with the following: criminal possession of firearm, unlawful discharge of firearm, 2 counts for endangerment first, breach of second degree, and charge 2 is weapons. You're charging officer report on 3/20/26, approximately 22:45 hours. Officers from the Meriden Police Department responded to Stower Drive on a report of a dispute involving a large crowd of people in the parking lot and one shot fired. Officers collected video footage of the incident, and you were identified as the male who fired the shot and left the scene in a red sedan. Meriden Police Department were able to identify you as Jacob Maldonado. After further investigation, Meriden Police Department had probable cause to believe that you had a gun and fired a shot on 3/20/26. Per your special parole conditions, you are not allowed to have in your possession or control any firearms, ammunition, or any other weapon. Also, you registered on the CCW Weapon Offender Registry, which prohibits you from possessing or being in the vicinity of any type of firearm or ammunition. As a result of the findings, Meriden Police Department applied for an arrest warrant, which was granted on 4/7/26, charging you with the following: criminal possession of a firearm, unlawful discharge of a firearm, 2 counts of reckless endangerment first, breach of peace second degree. And so in regards to that charge, condition 1, obey all laws, obedience to the law. A judge of Superior Court of the state of Connecticut has determined that there is probable cause to believe you committed the crime of criminal possession of a weapon, unlawful discharge of a firearm, 2 counts of reckless endangerment first, and breach of peace second. cannot revisit this finding. Therefore, this charge will not be considered at the hearing. This means there's no need to take statements, testimony, or review evidence regarding charge one condition of the laws, obedience to the law. The state filed the following exhibits that are pre-marked for identification as Exhibit A, conditions of special parole, B, remain in custody, C, parole violation report, D, notice of parole violation, E, Meriden arrest warrant 4726, F, Meriden police report, case ending in 6274, and G is video footage. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
I did, miss, but I don't understand because I didn't get caught with no firearm or nothing.
Okay.
Well,
I'm not gonna,
that's all I asked you right now.
that's something you're gonna have to address in court, Mr. Mullen. I don't want you to put anything in the record about that at this hearing, but you'll address that in court with your attorney.
So do you need to continue the hearing to obtain any additional evidence?
I do not.
We have no witnesses. So at this time, it is the defense's opportunity. If you'd like to respond, make short statements, and testify with respect to probable cause and severity of the allegations you made.
Thank you. So, Mr. Maldonado, he does have the case pending, which is the basis for remand. That is ongoing in New Haven at this time. He does want to put on the record that he does dispute these allegations. He does indicate he plans to contest these allegations in court. I do understand that probable cause was found in the warrant. I did explain that to Mr. Maldonado, but he did want to attend this hearing to have the record reflect that he does dispute these charges despite a judicial finding of probable cause that's been made. I will also note the alleged weapon does not appear to have been recovered. That can make it difficult to prove some of the elements of criminal possession of a firearm. And he's going to address that in court with his attorney going forward. These charges do appear to be the sole basis for the violation. There's no indication in the PDR that he was otherwise non-compliant with any of his parole conditions. He appears to be doing well up until this incident. Based upon the pending charges, Mr. Maldonado is not going to put anything on the record today with regard to the charges, but he does contest these charges and he will contest it fully in court with his attorney. Thank you.
Thank you. All right, so what I'm going to do next is I'm going to announce my findings. So obviously, well, there is a finding already on that charge one. So regarding charge two, I do make a finding of probable cause, obey all laws, weapons based on evidence presented in support of the violation, exhibits A, E, F, and G. And I do find the act is serious enough to warrant revocation. I've determined you detain while you wait for revocation hearing. So after disposition of these charges, we bring you back to determine if there's a violation or not.
I'm gonna max my shit up. I don't even know how to fucking boom it first. That's straight. I'm max up in 5 months.
All right, have a good day. Attorney Dean?
Hi, how are you?
Hi, good, how are you? If Aponte's there, I'm gonna call him in first.
Perfect, thank you.
Okay,
I think you have to turn the camera on. We can't see you guys.
all right, hold on, let me see. There we go.
Perfect.
Do you have
Um,
somebody you want
Is
first?
Mr. Aponte there?
Yeah, both of them are here.
Can I see Aponte first, please?
Okay.
Thank you.
You can head back.
Morning, sir.
Hey, good morning. How are you?
Good. So I'm gonna go on the record now. Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing starting Aponte George, number 396904. Today's April 29th, 2026. Hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing. Public access to the hearing is available with video live stream. Can you just state your name and inmate number, sir?
Yes, it's Jorge Aponte, 396904.
And turn over to counsel.
Yes, for the record, Hannah Dean on behalf of Mr. Aponte. Would just at this time respectfully request a brief continuance to the next available hearing date on May the 12th for my client. We are trying to obtain additional evidence that we've been trying to get for his hearing. I will note for the record, update his parole officer, PO Fam, and let her know this request as well via email this morning.
Okay, so I'll grant the continuance to May 12th, 2026, which is my next available hearing date. So that will conclude today's hearing. Mr. Aponte, we'll see you on the 12th.
Thank you so much. You guys
Thank
have a
you.
blessed day.
I'll set up
Thank
a
you.
call with you, okay?
Okay, thank you, Ms. Anna.
Thank you very much.
Have a
Thank
blessed
you.
day. Thank you so much.
Have a great day. Thank you.
Have a good day.
Morning.
Good morning, Mr. Tomlin.
Yes, Tomlin.
We're here today for your revocation hearing, and I have your attorney here, so we're gonna get started, okay?
Yes.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Tomlin Jason, number 310736. Today is April 29th, 2026. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing, and public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Jason Brunel Tomlin Jr., inmate number 310736.
Thank you. And you have counsel here today?
Good morning, Peter Matthews with the Public Defender's Office, Mr. Tomlin.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is at least you place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibit file for the record. Counsel will then have an opportunity to present relevant testimony. After considering all of the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, important rights, the right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence in support of your case at the hearing. You have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we now review the charge, state your appeal is bringing against you, any information underlying each charge. So charge one, under obey all laws, obedience to the law. You're charging officer report on 2/28/26. You're involved in a dispute with your girlfriend and a struggle ensued. She reported you placed her in a chokehold, elbowed her in the eye, and punched her in the lip, causing her glasses to shatter. As a result, Hamden PD issued a warrant for your arrest with the following new charges: assault third and disorderly conduct. You're in violation of parole agreement number 2. You're scheduled to appear before the Meriden GA7 court on 3/25/26 under docket ending in 3054-S for the aforementioned charges. And the state has filed the following exhibits that were identified at the time of the preliminary hearing. Those were exhibits A through G, with no new evidence submitted by the state. And defense counsel has filed the following exhibits that are pre-marked for identification as defense exhibit 1, which is a list of parole accomplishments and future plans for paroling statement. Exhibit 2 is a support letter from Nancy Jordan. Exhibit 3 is a flagger training course certificate. Exhibit 4 is support letter from Lisa Miller of Restaurant Depot. And Exhibit 5 is adult learner's permit. Do you need to continue the hearing to obtain any additional evidence?
I do not.
I did receive an addendum from PCS. The addendum reported on 3/25/26, Pearlie Jason Pomling appeared in Meriden Courthouse, GA7, under docket ending in 3054 for the charge of assault third. Mr. Tomlin received 364 days jail, execution suspended after 30 days with a conditional discharge of 18 months for the charge of disorderly conduct. The other charge was nollied. The EOS date that was on this new conviction was 4/10/26, so that sentence has been served. That was issued for the 30-day jail. Do you need to continue this hearing to obtain any additional evidence?
I do not.
Do we have any witnesses? So it's now a defense opportunity. If you'd like to present evidence, speak to any of the evidence submitted at this time, you may.
Thank you. So Mr. Tomlin, he did enter an Alfred plea to a misdemeanor charge here and received a conditional discharge after 30 days. All the charges he was facing here were misdemeanor in nature, and this was the sole basis for this violation. I will note that complainant in this case was also arrested. She was actually arrested on more serious charges than Mr. Tomlin was facing, and she still has a felony charge for this incident pending in court. Initially, she did not want to discuss the incident with the police. However, after she became aware that a warrant was being prepared for her arrest, she then went to the police to make allegations against Mr. Tomlin. He does deny his allegations. However, given the nature of the remand, he elected to enter a plea so that the parole process could proceed. If there is a finding, I would like to hear further with regard to sanction. Thank you.
Thank you. All right, so what I'm going to do next is I'm going to announce my findings in regards to that charge. So regarding charge 1, I do find you violated the condition, obey all laws, obedience to the law. This is based on your conviction of assault third, received a sentence of 364 days jail, suspended after 30 days with 18 months conditional discharge. So that includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. The purpose part of this hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Thank you. So Mr. Tomlin, he's 38 years old. He was born and raised in Connecticut with his family. He has a very good relationship with his family who still live in Connecticut. They are a source of support for him, including his mother, his father, and he has 11 siblings. Prior to his remand, he was residing in his own apartment that he did obtain through the Project Longevity program. Although he believes this apartment is still being held for him and is available going forward, he did propose a sponsor as well that was included in the mitigation report and submitted as an exhibit. Mr. Tomlin would prefer not to put the sponsor information on the record at this time, but it is included in the mitigation report as evidence. So Mr. Tomlin, he did earn his GED and he continued his education. He was studying computer networking at Brantford Hall. He has completed additional courses. Some of those certificates were included. He completed a safe driving course through DMV and did obtain his adult learning permit. He is planning going forward on working towards his license, and he wants to get a Class A CDL as well. Ultimately, he would like to get a CDL so that he can work as a truck driver, and he's been working towards that. He can continue working towards that. Prior to the remand, Mr. Tomlin was employed at the Restaurant Depot in the deli department. He'd been working there for about 7 months. He has a very good relationship there with his supervisor who liked him and was very supportive of him. And Mr. Tomlin did indicate he would be able to get rehired once he is released. A letter of support from his supervisor was included as an exhibit as well, which does support the position that he was a good worker and he was well liked there by his supervisor. Prior to working at Restaurant Depot, he was employed at Townsend Tire. He had also completed that flagger training course through NCS Learning. I do think he's demonstrated a very good work ethic and ability to maintain employment and maintain good relationships with his supervisors and coworkers. I think he's going to have no problem getting work and maintaining work once he is released from incarceration. Mr. Tomlin, he was very involved in the Project Longevity Program since he was released from incarceration, and a very supportive letter from Nancy Jordan, who was a case manager at Project Longevity, was submitted as well as an exhibit. The Project Longevity Program was assisting Mr. Tomlin with employment training and opportunities and housing assistance, and he does plan on continuing to work with them when he is released. He is very appreciative for the assistance and counseling they have provided for him, and he has very good things to say about that program. In addition to working with Project Longevity, Mr. Tomlin is working with parole with regard to additional treatment, and he's always been very cooperative with all the referrals that parole has made. Mr. Tomlin did engage in domestic violence counseling. He had just started the Explore program prior to his remand, and he's certainly willing to continue to cooperate with this or any additional treatment that parole recommends going forward. The mitigation report also summarizes all the treatment he underwent while he was at the halfway house. And I think the comments from the treatment providers that are listed there do demonstrate that he did very well in those programs. His parole officer did confirm in the PBR that Mr. Tomlin had been in complete compliance with his parole conditions prior to this remand. His special parole, it began in October 2025, and prior to that, he'd been under discretionary parole supervision since June of 2025. Mr. Tomlin, he's apologetic about the circumstances that led to this remand. He's frustrated. He was doing very well, and he thought he was on the right track, and things were going very well for him prior to this incident. I do think he could benefit from additional domestic violence counseling as being recommended by parole, and he's certainly willing to comply with that condition. He's also willing to comply with the no contact condition that's being recommended by parole. I think other than this one isolated incident, by all accounts, Mr. Tomlin was taking advantages of the opportunities afforded to him. He was working hard at his job, and with all the treatment he was recommended to undergo. As indicated, that sentence he received in court is expired at this time. I would ask that Mr. Tomlin be released at the next available date. He's looking forward to getting back to work, back to his family, and he's going to continue taking advantage of all the opportunities that he has going forward. Mr. Tomlin, is there anything you'd like to add?
I mean, I just want to get back out there to my family. They need me. I also have housing that's available for me that I need to pick back on. I talked to the people from housing. They said that they're still willing to help me. I have an apartment already that's on hold. I just need to get back out there. And my job is still waiting for me also.
Thank you.
Thank you, Mr. Tomlin.
So I'll be right with you with the recommendation. All right, so I'm going to put a few things on the record. I've listened to testimony today. I've listened to, I read all the evidence that was presented by the state. Did receive a new conviction, which you did serve the term of imprisonment already. You do have 18 months conditional discharge to follow your sentence. You were out there about 9 months before your return to custody. No prior violations or misconducts noted or issues prior to this incident. There is a history of domestic violence, so I do encourage you to attend whatever counseling or getting involved in the DV program as soon as you get out there. Because that's something obviously that needs to be addressed more. There are a lot of positive things I've read. I know you were doing well. There was a lot of these letters of support do show that you were engaged in the community and working on yourself, and you did find employment, you did have housing. So based on all of that, I am going to recommend that parole be revoked and that you be re-paroled for May 12th of 2026. This is approximate 2-month period of confinement as a sanction. I recommend the following parole conditions: no consumption of alcoholic beverages, operation of motor vehicle, behavior management program for domestic violence, no contact with your victims OC and RH, no contact with your co-defendants LG, J, S, general no contact AC and SD. My findings are going to go to the parole board on May 7th. The board agrees with me, then you'll be released on the 12th. If the board can hold you in longer, so just be aware, they want to hold you in longer, they'd call you back, you'd have a supplemental hearing, and the board would talk to you about any reasons why they may want to exceed my recommendation. So if you were there after the 12th, just know that you probably get a letter, or you can talk to your attorney. If the board doesn't want a longer sanction, you'd be notified of that. If the board agrees with me, you'll probably be gone before you even receive paperwork from us. But just know you could receive something in the mail from us. It takes about a week from the 7th to get it. It'll be sent to you regarding what the board's decision is and what your conditions would be. Do you have any questions?
Oh, ma'am, thank you. I appreciate it.
All right, well, I hope you do well like you were doing and stay out of trouble.
All right, thank you. Thank you, Mr. Matthews, too.
You're welcome.
All
You're all
right,
set there. Yep.
Thank you.